Okay, Liz, it's 9:30. We can get started.
Good morning. My name is Liz Kukla. I'm the Secretary of the Board of Zoning Appeals, and I'm going to read the preamble for you this morning, this Monday, February 6, 2023. In compliance with notification requirements of City's open meeting law and Section 101.021, the codified ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the City Planning Department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting have the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Please note that calling users can unmute by using *6. All meeting activity is being recorded via the WebEx platform. These proceedings are also being live streamed via YouTube for public view. We have provided a link to the meeting for those who wish to speak on a particular case via our website and email. All requests to speak on a particular matter have been considered. We've also received emails from those who have provided written comment on a particular matter. Back to you, Madam Chair.
Thank you. Good morning and call the roll, please.
Thank you. Ms. Roca? Ms. Faith?
Present.
Ms. Brown?
Present.
Ms. Holzer?
Present.
Ms. Britt?
Here.
Madam Chair, we have a quorum with 4.
Ms. Roca is present as well.
Thank you. Okay. Madam Chair, we do have one postponement this morning. It's all right for me to go ahead and jump in.
Go
It's
ahead.
calendar number 22-219 regarding the appeal of FEB Inc., who is appealing the decision of the Director of the Office of Equal Opportunity. They have requested a postponement to March 13th as they need more time to prepare.
Is that March 13th?
Yes.
Okay. Without objection, board?
Without objection.
Without objection.
All
Thank
right.
you, Madam Chair. So anybody that's here for this, there will be no testimony for that case. And we will, if we sent you a letter, we'll send you another letter before the hearing, before the next hearing. And I believe that's all that we have for postponements and withdrawal this morning.
Thank you. Maurice, I think we're gonna get started with
we have Councilman Harsh on line this morning.
All right. We'll get started. So our first case is calendar number 22-228. This is at 4015 Gifford Avenue. Sarasova proposes to establish use as a residential facility in a C1 local retail business district. The owner appeals for relief from the strict application of the Cleveland codified ordinances as stated in the agenda and the public record, of which there are 2. And with that, I will hand it over to Ms. Brown for the oath.
Thank you. I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply, I do. State your name and your address, please.
I do. Chris Harsh, 601 Lakeside.
I do. Connor Gale, 2209 Oakdale, Cleveland Heights.
I do. Leo Silva, 6096 Parma Heights, Ohio.
I do. Raven Oglesby, Nami, Ohio, 1225 Dublin Road, Columbus, Ohio, 43232.
is this all for the Gifford case?
Yes.
Yes.
Okay.
Anyone else? Thank you, Madam Chair.
Thank you. History of the property, please.
Thank you, Madam Chair. This property was originally zoned general retail in 1929. In 1991, it was changed to local retail business. Madam Chair, we did find that there is another BZA case in 1999. A variance was granted to use property as a group home for 5 unrelated adults. And then, Madam Chair, we see that in 2020, a permit or a miscellaneous document, which I'm not sure what that is, I apologize, but in 2020, a license for Sally Ann's adult care was applied for, and that document is closed. And then, Madam Chair, I believe that that's all that we have that is relevant. Thank you.
Thank you. Legal standard, please.
Madam Chair, members of the board, appellant is requesting an area variance from the minimum distance requirements of the zoning code. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code.
Thank you. Who will be the spokesperson for this case?
Leo Silva.
All right, Mr. Silva, go ahead.
Not sure where to begin except for we've ran the business here for 28 years, me and my mother together. My mother recently passed away. I'm trying to take over the business, and right now we have currently we have 13 residents and 2 live-in managers, and I really don't want to displace them. I mean, that's where I'm at with that, and I am not sure what this variance is about because it's already been a business for 28 years.
That's a good question. Someone with city planning can chime in on that.
That would probably be more of a Liz Kukla or Rick Riccardi question. I was not aware that there was a variance issued in 1999. I don't know if it was continuous or not, and maybe that's why we're here today.
Yeah, that's what I
Mr.
was
Riccardi
thinking. Like,
would.
I don't know how it expired some kind of way, or I don't know what's going on. So yeah, maybe if someone can give me a little bit of background on that.
Madam Chair, I don't see that the permit was issued ultimately. I don't know if there's anybody here from Building and Housing, but I believe that's why we are here today. The variance expired.
Okay. So, Mr. Silva, this has been a. Oh, I'm sorry. Go ahead, Mr. Riccardi. I can hear you, Mr. Riccardi. Can you repeat that?
I mean, what's evident is that even though there was a variance obtained, the subsequent permit was not obtained or issued for it, and that's what happened.
All right, great, thank you. All right, so Mr. Silva, you've been in business for how long?
28 years. It was actually me and my mother's. My mother started it, and me and her kind of worked together to get it where it was. And I also went ahead and I spoke with all my neighbors. I went farther than the 200 foot, the 200 feet we were supposed to go, and I went from corner to corner, and none of my neighbors opposed me in any way whatsoever. So that's, that's where I'm at with that too.
Okay.
But we kind of, like I said, my mom passed away, and we ran the business together, and we actually lived on Memphis, and me and my wife have actually moved in with my mother so we could like run it's like a family business.
Okay, thank you. Mr. Gale?
The Old Brooklyn CDC has met with both Leo Silva and Chris Harsh. The drive-by of the properties show that they were all in good condition, good standing, but we will support Chris Harsh's decision ultimately. and his comments moving forward.
All right, thank you. Ms. Oglesby?
Yes, I would just like to add that we represent, NAMI Ohio represents over 5,000 of the most vulnerable Ohioans struggling with mental health. And part of that work that we do is we have the Ohio Adult Care Facility Association, which follows very closely adult care facilities, class 2 and class 3 residential facilities that are certified through the state of Ohio and the Department of Mental Health and Addiction Services. Because of this occupancy permit not being available for these 2 homes, the state is actually holding on. They have been waiting, diligently waiting for this process to happen so that they could go ahead and move forward with Mr. Silva. With the passing of his mother, that requires new certification and new occupancy report permits. And so that's right now, this is really holding up the process because he hasn't been able to get these occupancy permits, but he has them for the 3rd home. That is, they've already gone ahead and went forward with that one. So it is our hope that we're able to resolve this because at this point, this will cause displacement of individuals who are being well cared for, along with staff. And right now, throughout the state of Ohio, we are working to preserve homes that are doing the right thing. I can understand in Cleveland that there's a huge number of adult care facilities, and some may be not seeking licensing and permitting. But for those that are, we work very closely with them and do training and technical assistance along with the state of Ohio. And so just at this point, licensing is waiting. And everybody's just kind of waiting for this process to happen so that they could move forward.
All right, thank you. Councilman Harsh.
Yes, thank you. Madam Chair, I appreciate your time this morning on this issue. I did have a chance to go out and talk with a number of neighbors in that area as well. And the good news is that the majority of the neighbors do support Mr. Silva's operation of the houses and report that they are doing a good job. There were some young ladies who are uncomfortable with the gentleman who lived there, but that discomfort did not rise to the level of incidents occurring between the occupants and themselves. It was more of a distance type issue. However, the majority of people said that they were good neighbors and they were quiet neighbors and that they had no overarching concerns. My concern, Madam Chair, is really about the cluster of 3 houses operated by Mr. Silva, all within 300 feet of each other, which is an absolute violation of the 1,000-foot distance. And the 1,000-foot distance exists for a number of reasons that I think are really, really important to the city of Cleveland. One is that the people in these houses are supposed to be dispersed into normal society. I'm throwing out my air quotes on that. But they're supposed to be living in neighborhoods where they can operate amongst, residential neighbors who are, the salt of the earth type folks, and they're not supposed to be clustered together. They're not supposed to have a region, a zone where they all are living next to each other. The idea is for their own mental health and treatment to be able to disperse them within the larger population. And when we concentrate these houses this close to each other, we take that away from them, and we create instead a district for adult mental health group homes. And that is not the purpose of even having these homes in residential areas in the first place. The second is that, the families of these gentlemen who reached out to me don't live in the city of Cleveland, and Mr. Silva doesn't live in the city of Cleveland. I know that he used to live on Memphis, but he lives in Parma Heights, and people never come to us. We don't see these homes in those communities. I asked Mr. Silva if there's any of these houses on his block, and there are not. And I'm sure he would welcome 3 houses around him of this type, but I bet his neighbors would not. And people always come to Cleveland and want us to be the good guy. They want us to be the one who cares. And yes, we do care. And I have a lot of compassion. I am not, to be clear, trying to shut down these houses. But I have a very, very grave concern about allowing this type of violation of the 1,000-foot law, because then what's wrong with the next one? Mr. Silva owns another house down at 4802 Gifford. He hasn't brought it up yet, but it's the 4th house that he owns in the neighborhood. What stops him from turning that into a group home as well? We've already decided that the 1,000-foot law just doesn't matter. And that is where my really big sticking point is. I have a couple of questions. One is, when was the 1,000-foot law enacted? Do we know the actual date that that became law? Because this could help clarify grandfather questions.
That happened in city council, so I know I don't have an actual date, and
Does
maybe
anybody in zoning know when that went into law? It was before me.
I am looking right now. I don't know off the top of my head. It was instituted by city council to pass this. I believe it was written by council.
Yeah, I know it was sooner than 28 years ago, though. So this house has been operating for 28 years.
Right. So I'm hearing that it's 2016, which probably sounds about right.
Yeah, that does. Somewhere in there.
My next question, Madam Chair, is at that time, were all existing group homes in Cleveland grandfathered at that point?
That's a good question. I would assume so. I can't think you can go back and then kick people out after you've enacted something.
I mean, I think that would be a Rick Riccardi question, because he would be the one that would be administering those, but I would think they would be grandfathered.
Mr. Riccardi, do you know?
The answer, right, this is Richard Riccardi. The answer to that is yes, but the ones that have obtained a permit for their use, yes, they were grandfathered in, and that's why you will see on the zoning map some obviously established and clustered together within 1,000 feet. So if there was if they had established the use, yes, they did receive non-conforming rights. If, like anything else, you're just operating without a permit, then you don't establish non-conforming rights. And I think that's probably the case here.
They were granted the variance, but they never used that variance to get the permit, so they never actually fell into compliance. And when 2016 law was passed, they were not in compliance at that point. So that brings us here today with the changing from Sarasova to Leosova. The state has flagged this for needing occupancy permits, and that brings us to BZA today. So my question then becomes to the board, Madam Chair. Let me step back. I have a big fear, and I have to be honest about my fear, because I find that honesty is the best policy. I heard nothing but good things about Sarasova. Leo, people loved your mother, and she seemed like a wonderful person, and everybody said very nice things about her. But nobody mentioned you. And I have a fear that Mr. Sova has inherited a business. He has inherited some income, and it's his goal to maintain that income. And I do not have record from people saying that he has been a great operator. And I apologize. This is harsh, and I know what words I'm using. But I don't know that we're going to get the same caliber of operation out of the son that we got out of the mother. I just can't guarantee that. So my question to the board is, can we apply a conditional variance or a conditional permit to allow some time for Mr. Sova to operate these establishments and give us as a community some time to see how his operation fares or compares to that of his mother, so that we can ensure that we're not giving permanent variance to this operation until we know that Mr. Sova is a good operator and a good neighbor in the community.
Yeah, I don't think so. Can someone either from legal or, because I know with once we grant the variance, it's with the property forever.
What about permitting? Can we grant conditional permits?
Now the permitting, that's the building and housing question.
Can we get an up or down answer on the conditional variance?
Mary on the phone, our attorney, Madam Chair.
I don't have any history of, have we done this in the past? I don't think so.
No.
I mean, with variances, like I said, once we grant it up or down, it's with the property forever. Now, I don't know anything about permitting. I don't know.
But doesn't the state, the woman that was on from the state, doesn't she follow these regularly, and wouldn't the state kind of be ensuring that he's a good operator?
I believe that Ms. Oglesby is with an advocacy organization and not with the state of Ohio, but I could be wrong. Correct me if
Oh.
I am.
So I am with the National Alliance on Mental Illness and the Ohio Adult Care Facility Association, of which we work extremely close with the Department of Mental Health and Addiction Services, and the licensure department, along with those that oversee adult care facilities. As stated before, we work with the home operators to ensure that they have all that they need, resources, and the ability to operate their homes. These homes are highly regulated by the Department of Mental Health and Addiction Services. As Mr. Harsh is talking about his fears, I also have fears. I have fears that when we take the stance of giving conditional to see how somebody's going to operate, if that's not something that's happening with everyone else, to do that here, I think is, as you said, it's a bit harsh. These two homes, as you stated, if he's been involved in the business up until now, that means he's had some input, he's had some operational authority in being able to do this work. I think we're kind of prejudging before we even get to see the result. And I think these type of responses is what will lead to people being homeless. So I think fears are here on both sides. It's very concerning to hear that, particularly Mr. Harsh, with your background, that we aren't really thinking about the individuals that have been in this home. These individuals are mentally disabled. Some of them are seniors. If they're displaced and they're back on your streets, is that better than being in the home that they're in? That's the question that I have.
Sure.
Well, there's
And
no,
so-
yeah, I'm sorry, but there's no back and forth answering questions without me. But I guess what we really want to get to is, I guess building and housing needs to answer whether there can be a conditional permit put upon the house or not. And if they don't have an answer, I can tell you that for BZA, if we grant this variance today, or we don't grant this variance today, it stays with the property, period. So, I've never heard of a conditional permit, but like I said, I can let building and housing speak on that if they know of anything like that.
Madam Chair, if I may.
Riccardi, all I can say is that, excuse me, the use will not be permitted. The use can't be permitted without receiving a zoning variance. And then we would, of course, we would follow the terms of whatever conditions you put in the zoning variance.
Councilman?
Yeah, thank you, Madam Chair. And I am very concerned because I understand that the variance goes with the property, not the operator. So Mr. Sova could sell this business to somebody else and the variance would travel to that new owner. And this is why I'm so concerned about knowing that the operation is well managed, because this is a cluster of 3 of these houses within 300 feet of each other, not the intent of dispersing people into residential communities. If I understand what Mr. Riccardi just said, Madam Chair, he said conditions of the variance. What conditions are available to the variance, or is it a straight up or down, yes or no to the variance?
Yeah, our conditions don't go with if someone owns it and like 3 months later, if they get kicked out, we don't do that kind of stuff. It's just for the variance. So we'll either grant the variance or not, and it'll be with the property. So our conditions will be, we've had conditions like, you can get it ratified once you like fix the railing on the front porch or something like that. We're not getting into who's owning it and all that.
Yeah, Madam Chair, if I may, I concur with Old Brooklyn CDC. The homes are well maintained. They simply are. I have no concerns about the conditions of the exterior. My concern is that we have a change in ownership. We haven't had a chance to see how the new ownership is going to operate the business, or even if they plan to operate the business.
No, I understand your concern, but I'm just telling you where we are with it. So
yeah.
you just have to let us know, whether you support it or not, because I don't think we can do what you are asking to be done by the BZA anyway.
And I suppose my only recourse then is to talk to the permitting department after a variance is granted to see if they can make the permitting conditional. Does that sound correct?
Madam Chair, can I jump in real quick?
Sure, go ahead, Ms. Roca.
I just want to mention that this is the state licensure process applies here. So if there was an issue with the property, you could presumably go to the state and try to rescind their licensure. I think that's one option that's not been discussed, so I just wanted to bring that to the table for Mr. Harsh.
I appreciate that.
Madam Chair, may I ask a question or make a comment?
Sure, go ahead.
Councilman and Mr. Sova, have the two of you had a conversation about how Mr. Sova was previously involved with his mom in running this business? He's made that statement. Perhaps we should ask him about that if you haven't already done so.
I'm leaving time for Mr. Sova to respond.
Oh, I'm sorry. Okay, I just want to say that I actually quit my job that I was working as a lead at Athens Foods to run this business. The business is not for sale whatsoever. I promised my mother on her deathbed that I was going to run that. That was her wish for me to run this business. I want to hand it to my kids. I want them to do this is family business for 28 years. I do not plan on walking away from it. Also, the house that you addressed up the street from there, I'm currently renting that to my niece, and I'm making all the repairs that need to be done on that house because for 3 years I was taking care of my mother for 20. It had to be 24-hour care, and I'm catching up with everything. I like my neighborhood. I like all my neighbors, and we've been here for a long time. It's like the people are not only clients to me, they're also family. They've been there for 15 years or longer, some of them. So I just wanted to say that.
Madam Chair, if I may, one last thing, and I'll stop.
Go ahead.
Thank you. I appreciate what sounds like, and I have to believe on face is a sincere commitment to this. I brought up the distinction between Mr. Sova and his mother because I asked, I talked to 20 neighbors, and they all talked about his mother very fondly and kindly, but that's the only person they talked about. So I just wanted to be clear on that. I'm not, as I said earlier, trying to evict anyone or shut any houses down. I'm trying to figure out a way that we can enforce the laws of the city of Cleveland in a way that is fair to not only the clients of these homes, because again, they're not, the purpose here is not to create a mental health district, but also to the people of the city of Cleveland who are overwhelmingly burdened with the task of housing these residential facilities within our communities when neighboring communities do not. It's a frustrating situation. I've seen far worse situations up the road, around the corner, and I understand how these things look when they go bad. So I defer to the board. I am not opposing the variance. I am wanting to make sure that we can respect the needs of the neighborhood long-term, as well as the people that live there now. And so that's all. I guess I'll take this up with permitting and see if there's a way to conditional that, just so we can make sure that this is operated well, as to make sure that Mr. Sova is sincere and runs it as well as his mother did. Thanks.
Madam Chair?
Thank you. Yes.
Excuse me. Could we put a condition in the, I'm not sure if this is going to be strict enough for the council person, but could we put a condition into the resolution stating that the operator must keep his license current or, in good standing or something like that? Could that give us a little bit of the ability to form?
Yeah, I don't think it's something we can enforce. Like, that's the thing. Like, our conditions need to be something that we as a city can enforce, and we can't enforce that. So
okay,
we can put it in there like we would like that to happen, But
Yes, and I was
it's not
thinking because,
anything,
Mhm.
yeah, it's not anything we can enforce as the city, so.
okay, I think that makes sense. Just, I'm going off of what Mr. Riccardi stated. And I
Mhm.
think that, you know, the more conditions, if we could put some
Yeah, we
conditions.
try to
clear-
add some kind of language like that, you know, is preferred, you know, but it's not
Madam
anything
Chair?
we can enforce.
Madam Chair, I think, and Mr. Riccardi or Maurice can chime in, but I'm pretty sure the codified ordinances require the residential facility to be licensed. So that would be a condition that's probably already in the law, but I would need confirmation of that.
I think you're right there.
Mr. Riccardi would probably be the best to answer that. I'm not sure that that a license is required from the state.
All I can say is the very definition of the residential facility use does state licensed. So if there would become a time when you were no longer state licensed, then you would no longer be by definition a residential facility.
Thank you. Yeah, thank you, Mr. Riccardi. That's
Right.
exactly what I was referring to. So the law provides the licensure requirement in itself. So we don't need to condition that because the codified ordinances already require it.
Actually, it does, yes.
Thank you. Maurice, did you want to chime in for city planning on this one?
Yeah, this is a complicated one. You know, first of all, this isn't a local retail district. Had this come in all by itself, without having a couple of others on the street, we probably would have had no objections to it whatsoever, and it would have sailed through. It's at the end of the block. You know, we normally don't like them mid-block and prefer them to be, you know, on the ends of the streets where it's not like running a business in the middle of the neighborhood. That being said, it's unfortunate that the permit expired, or we wouldn't even be here right now today.
Right.
Because they would have been grandfathered in. So that's very unfortunate. I did discuss this with the councilman earlier on. We exchanged some emails about this, and he did tell me that, you know, that they are a great operator, that, you know, and everything that he stated, you know, that the neighbors have had no trouble with them for these 28 years. I'm going to have to go on faith and say that, you know, we're going to believe what Mr. Sova is saying, and that he will continue the business in the manner that his mother maintained, in good standing and with no issues with the neighborhood. So we're going to support this. But I do have to state and agree with the councilman that, you know, there is a reason why council passed the law to avoid clustering of these types of homes. It's better for all of the homes to have a greater separation so that they're not all right next to each other, and you're getting a large volume of the residents in one particular neighborhood. So I would like to say that, you know, we judge each one of these on its own. And I don't see this as setting necessarily a precedent. It's something, again, that they have been in business for 28 years. So this isn't a new use. So I'm going to go ahead and agree with the councilman and recommend approval for this house.
All right. Thank you, Maurice. All right, board, any other questions? Hearing none, I'll entertain a motion.
Thank you, Madam Chair. We've heard rather extensive testimony on this, and the reason it was postponed was at the request of the councilperson so that he would have time to research and have conversation with various entities in the area. We've heard from the CDC, we've heard from city planning, and while this is in a situation where there are two other homes within close vicinity, as city planning, Mr. Rulins has stated, the permit expired, otherwise they probably would not be before us today. And again, this is a home that is next to backing up to a business parking lot, and is at the end of the houses on the street. I think the appellant has stated that The succession of business ownership is something that his mother, he vowed to his mother he would take on. And so in this particular case, we are assuming, since he's quit his other job, that he has every intention of operating it at the same caliber as his mother did. So with all that being said, Madam Chair, I move that we go ahead and approve this variance for calendar number 22-228.
Thank you. Can I have a second, please?
Board Member Roca, I second.
Ms. Roca with the second. Go ahead, call the roll.
Ms. Brown,
Yes.
Ms. Holzer,
Yes.
Ms. Roca,
Yes.
Ms. Faith,
Yes.
Ms. Britt.
Yes.
Calendar number 22-228 is granted. It'll be ratified next week when we meet again, and we will send the appellants a letter.
Thank you.
Thank you. Okay.
All right.
I think we're gonna do the other stuff first, Maurice. So let's go to Chatham.
Are we skipping Councilman Griffin, the 23-007?
Is he on?
No, that was what I had next after 41.
Oh yeah, no, we can do that one. That's fine.
Okay.
Just one second while I find it. We have a lot of letters for the other case. So that one has been postponed.
Great.
That's the next case.
Our next case is calendar number 23-007. This is at 1905 East 89th Street. The Cleveland Clinic Foundation proposes to construct a temporary parking lot for 5 years in an E2 residence office district. The owner appeals for relief from the strict application of the Cleveland codified ordinances, as stated in the agenda and the public record, of which there are 3. And with that, I will hand it over to Ms. Brown for the oath.
Thank you. I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply I do, state your name and your address, please.
Chris Bednar, 15426 Lake Avenue, Lakewood. I do.
I do. Vicki Johnson, 1665 East 82nd Street, Cleveland, Ohio, 44103.
I do. Peter Volis, 9500 Euclid Avenue, Cleveland, Ohio. I do. Antonio Montemarano, 9500 Euclid Avenue, Cleveland, Ohio.
Jim Sedek, I do. 9500 Euclid Avenue, Cleveland, Ohio.
Thank you. Anyone else for this case? Madam Chair.
Thank you. History of the property, please.
Thank you, Madam Chair. This property was originally zoned general retail in 1929. In 1966, it was changed to residence office. Madam Chair, I think the most pertinent information that we found is that it's historically this parcel has been used as multifamily, but that in July of 2020, a permit was issued to demolish a 2-story structure on site. That's all that I have. Thank you.
Thank you. Legal standard, please.
Madam Chair, members of the board, appellant is requesting area variances from the temporary permit, grading, paving, and fencing requirements of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code.
Thank you. All right, who will be the spokesperson for this case?
I will be. My name is Peter Volis.
All right, Mr. Volis, since it seems like all of you all in the same room, you can call on each other when you're ready to speak, but just say who you are for our reporter.
I'll be the primary spokesperson for the clinic at this time. If I need support on some questions, I will ask my colleagues to introduce themselves.
All right, great.
Okay.
Go ahead.
How's the sound in the video? Can you hear us okay?
We can hear you.
Great, thank you. Again, my name is Peter Volas. I work for Cleveland Clinic as its Senior Director of Real Estate, which is part of Buildings and Design. We are presenting an application to construct a temporary parking lot for 3 to 5 years in an E2 residence office district. Specifically, we are requesting relief from 3 sections of the ordinances as submitted. The site is located in the northwest quadrant of Cleveland Clinic's main campus. The area in question totals approximately 3 acres, which is further defined as Chester Avenue to the north, Health Space Cleveland, also known as the Zaloni Plaza, to the south, East 90th Street to the east, and East 89th Street to the west. The entire area is owned by Cleveland Clinic. A site plan with a parking arrangement has been submitted. The area can hold up to 332 parking spaces based upon space measurements totaling 9 feet by 18 feet. Currently, the southern portion of the site is used for the proposed purpose. The balance of the site is substantially vacant. The grade slopes slightly from the north to the south, but drainage should be contained to the defined area due to the compacted gravel site, which is proposed. A fence is proposed around the entire area with curb cuts along 2 areas on East 89th Street and 1 area along East 90th Street. The benefits of this request include a self-contained area for daily construction workers. Second, the avoidance of the same construction workers parking along the street or in adjacent neighborhoods, and interim use, and thirdly, an interim use until a broader plan has been developed for the site. Thank you for your consideration.
Thank you. Anyone else from the project team want to chime in here? If not, I'll go to city planning.
Maurice Rowland from City Planning. Just a question to the applicant. You're stating an 8-foot tall fence is being proposed. Did we get any kind of a detail of what that 8-foot fence was going to look like? And would there be any screening?
At this point in time, no screening. It's just a regular chain link fence. No screening is planned due to security purposes.
So, Madam Chair, as you know, in the code, this goes way beyond what we would consider, the code would consider a temporary parking lot. However, I don't think we have many other businesses in the city of Cleveland that operate at the scale that the Cleveland Clinic does, in as far as their construction projects that seem to be going forever, which of course is a good thing for the Cleveland area. So we understand the need, and we do agree that having the parking lot will definitely help to keep contractors from parking on the side streets and clogging up the neighborhoods and causing a problem there. And I will say that also where this is being located, it's currently unused vacant land, and the contractors will have to walk a certain distance to the construction projects, which I don't necessarily think is a bad thing. And so we're concentrating the parking all in one area. So we would support the requested variances.
Great, thank you. I have one question. You say you need this lot for 3 to 5 years, but we can't really say that in our resolution if it becomes approved. So I need an exact time frame of how long you want this to be a parking lot.
Madam Chair, can you, I want to better understand your question. So you're saying that.
Yeah, you're saying that you need this for 3 to 5 years. We can't put from 3 to 5 years in our resolution. So you need it for 3 years, 4 years, 5 years, like we need an exact number.
Okay, I'm going to go with the larger number in 5 years.
Okay, thank you.
Which is the duration of the largest project that is under construction on our main campus, which is the Logical Institute.
All right, thank you. So we have a 5-year horizon here to end February 2028. All right, board, any questions?
Yes, Madam Chair, I have a few.
Go ahead.
The house or the structure that's on East 90th Street, is that occupied?
So that property is owned by a third party. It's known as the CLE Apartment Suites. It is not owned by the clinic. It is occupied. It's like a bed and breakfast or an apartment building.
No problem.
Short-term uses.
Yeah, I just wanted to know if it was occupied, and if it is, the question is, how close are you going to build the parking lot to that structure? Is there some kind of side yard that, lights are not in? Well, I guess you're using this for daytime parking. I'm not sure. You did.
Right.
You said construction, but it doesn't look from the site plan that there's any setback from that structure. I can't tell.
Yeah. There, if you zoom in on the aerial, you might be able to see a little bit better. There is a bit of a setback in the back. I don't recall how to the distance of that is, about 30 feet, maybe.
My question is on the side.
On the sides, there's nothing. Our project is not going to include the area to the south of the apartment building. That is land. It's owned by Cleveland Clinic. It's just used as a surface lot.
Okay.
It's not part of this project. And there's
So it means you're doing it on the property line. Okay, thank you. And to city planning, Chester Avenue is a prominent street. We're not going to require any kind of screening, landscape, anything, just a 8-foot chain link fence for 5 years?
We would be more the contractor, but they said they were not proposing that. I guess I'm torn for security reasons, whether we want to have anything on Chester, and this is a temporary lot. I don't know in 3 to 5 years if landscaping would get to a mature enough point that it would even, provide much of a screen. So it's kind of I've wrestled with this same issue. Thank you for raising it. I guess I'm torn on this particular issue. I could see where screening would come in handy, maybe because Chester is such a heavily traveled street, but sometimes keeping it open and the security from that is also a good thing. So.
Okay, so I won't require it. I appreciate understanding that there was a discussion and you weighed the pros and cons. That wasn't presented and was of concern.
Yeah, sorry about that.
That's it, Madam Chair.
Thank you.
Chair, I have a few questions.
Go ahead, Ms. Roca.
The first is to the appellant, Mr. Volas, if you could speak to your difficulty with complying with 34907 about the graded drainage. Is it because it's a gravel lot that you don't have the drainage, or you can't meet that requirement? And then my second question is the city planning about the curb cuts. Can you just speak to whether the city is comfortable with the location of the curb cuts? Thank you.
Reason existing.
With regard to the material that's being used for the lot, we looked at concrete and asphalt, and we feel that gravel is the best use for this site. One, because it's construction workers, obviously. Two, because any sort of water will go back into the ground and not cause more problems for drainage, runoff. If you could use those other two surfaces, they're impervious and it's going to cause other challenges. Plus, between the freeze thaw seasons, it's just going to create other issues for the area. And like I said, this is just an interim use until a broader use is developed for this site and others across our campus. And with regard to the curb cuts, there are no curb cuts along Chester, and there's 2 curb cuts along East 89th Street and 1 along East 90th Street. And just to bring your attention, on the East 90th side, there is the strip along Chester that prevents you from turning left on the East 90th Street. So that's why we went with the plan that was proposed. Does that answer your questions?
It does. Thank you.
Thank you. Any other questions, board? If not, I'll entertain the motion.
Hearing no further questions or comments, Madam Chair, I'll move forward. I am visiting the Cleveland Clinic main campus with a great deal of frequency these days. And so I'm quite aware of the land development going on. I think to Ms. Brown's question with regard to screening along Chester, the north side of Chester has numerous parcels that are under construction. And so I think for the time being, it makes sense, as the discussion has already happened, that there be no screening until, everybody is settled on both sides of the street and can move forward with more of a master plan. I'm assuming to our appellant that the gravel is just a number 10 gravel.
304. It's 304. Oh, now
304. Okay, great. So that will allow for the permeability and helps with the drainage, since this is a temporary situation. And it looks like from the aerial view that the curb cuts are already existing. Is that correct?
That is correct.
Okay. So with that being said, Madam Chair, and we have a commitment from the project team that this is temporary with a 5-year horizon to end February of 2028. I move that we go ahead and approve this variance for this project.
Thank you. Can I have a second, please?
Member Brown, I second.
Ms. Brown with the second. Go ahead, call the roll.
Ms. Holzer,
Yes.
Ms. Roca,
Yes.
Ms. Brown,
Yes.
Ms. Faith,
Yes.
Ms. Britt.
Yes.
Calendar number 23-007 is granted conditionally. We will ratify it next week, and we will send the appellant a letter.
Thank you. Thank you.
All right. Thank you. All right, next case.
Our next case is calendar number 23-008. This is at 3611 Chatham Avenue. Terrace Wood LLC proposes to add a dwelling unit to an existing non-conforming 3-dwelling unit structure in a B12 family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances, as stated in the agenda and the public record, of which there are 2. And with that, I will hand it over to Ms. Brown for the oath.
Thank you. Swearing in all who are present for this case, do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply, I do, state your name and your address, please.
I do. My name is Karina Dumitrescu, address 25624 Woodpath Trail, Westlake, Ohio.
Sean Bronson, 2117 Ren Rock Road, Cleveland Heights, 44118. I do.
Anyone else for this case? Madam Chair.
Thank you. History of the property, please.
Thank you, Madam Chair. There's been no change in the zoning since 1929. Our Records Administration Office, we found only that in 1914, a permit was issued to erect a garage on site. And in 1917, a permit was issued for an addition to the property. There is also a permit that was issued in 1963 to correct violations to a 3-family dwelling. And then in the more recent history, we see that rental registration was issued to the property starting in 2012. And that in 2007, step back a little bit, I'm sorry, the permit was issued to board and secure first floor openings. But then we see in 2018, a permit was issued to erect a deck on the property. And I believe that's all that we have. That's relevant. Thank you.
Thank you. Legal standard, please.
Madam Chair, members of the board, appellant is requesting a use variance and area variances from the requirements of the zoning code To obtain the use variance, appellant must prove that denying the request will result in an unnecessary hardship particular to the property, such that there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code. Note that the area variance may only be granted if the board prescribes proper safeguards to preserve the character of the neighborhood and provided the 5 items in section 337.03C are met.
Madam Chair, it looks like Nate Lull still needs to be sworn in.
Go ahead, Ms. Brown.
Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand. Reply, I do. State your name and address.
I do. Nate Law, 3308 Lorraine Avenue. Thank you.
All right.
Can you go back to that slide?
Which one?
The context, the one before that, please. Thank you.
The aerial?
Sit here for 1 second. Yeah.
Sure.
Appreciate it.
All right. I lost my train of thought. Did we get the legal standard already?
Yes, we did, Madam Chair.
Okay, great. All right. Who will be the spokesperson for this case?
I believe I will. Karina Dumitrescu.
Okay, go ahead.
Hi. So my client, Sean Bronson, and I are applying for an appeal for, as was mentioned, a use variance and an area variance for this project. The building was purchased in 2021, I believe, in belief that that there were 4 units on site. There were 4 mailboxes, 4 utility meters. It was advertised as 4 units, and the client would like to renovate the entire building, upgrade the interior and exterior of it, and rent it as such. And that's basically where we are right now. I think the other specific conditions of the site is that it's a very unique site. It's a corner lot, but a triangular shape. It does not meet the area requirements, square footage of lot per unit, but I don't believe it did at any point in history, because even if there were 2 or 3 units on site, each of those units per zoning code requires 2,400 square feet. And right now we have 22 for the whole site. The other challenge that we have is to provide adequate parking on site given our restraints. But we're doing the best we can and proposing 2 tandem parking spaces. Other than that, there are no considerable changes done to the building on the exterior or even in the interior. We're keeping the exact footprint of the units. We're just upgrading everything in it. The one thing that we are doing, I think in 2018, a deck was taken out, and that is that little, those stairs going up to the 2nd level right next to the parking lot that you see right there, parking driveway. And I believe those were considered structurally unstable and also not code compliant. So we are planning to re-add those for access to the 2nd level, but obviously code compliant.
Okay, thank you. Mr. Bronson, did you have anything you wanted to add?
No, Ms. Dumitrescu did a pretty good job of encapsulating everything. We're not adding anything to the footprint of this structure. We're just improving it all throughout. Go ahead.
I'm sorry to interrupt. I missed. I saw a picture there. We do, in order to make for code compliance, we do have to add a very small shed dormer facing 36th Street, right there between the 2 roof levels.
Mm-hmm. Okay, thank you. We'll go to Mr. Law at the CDC.
Good morning, Madam Chair, members of the board. We would just request that this hearing be postponed until we have a chance to meet with the applicant. This is the first we're hearing of this project, so just want to better understand Mr. Bronson's plan here. So we'd ask that you postpone.
Who would we be meeting with?
Ohio City Inc. We are the local community development corporation for the neighborhood.
Is this a requirement, or is this something just in good faith that is practiced?
It is a good faith practice. It is not a
Okay.
requirement. So it's on you if you would like to postpone and meet with Ohio City Inc. or move forward.
I believe that that we would love to move forward as soon as possible. And that's not to say that we don't want to meet with Ohio City.
Are
We
you
would
still
love to do
amenable
that.
to meet with Ohio City? Even if we move forward today, are you still willing to meet with Ohio City?
I believe so, but I would leave it up to Sean to respond to that question.
So we'd be open to meeting with them, but since we bought this property and been awaiting to get the best plans and get moving forward with this renovation, we prefer not to have to wait any longer to get our permit to move forward.
Okay, well, I'll suggest that if your variance is approved, that we'll just put a condition in there that it will be ratified after you have a meeting with Ohio City. City planning.
Madam Chair, Maurice Rowland, City Planning. We would recommend highly that you do meet with Ohio City Incorporated to go over your plans and further flesh out some things. That being said, we get a lot of these with, people have purchased properties that they thought were 3 or 4 unit apartments, and it turns out that they've never been made legal, and that happens all over the city. I do think that the plans look very good for this. They're large size apartments. You've got mostly two. You've got what, 2 or 3 2-bedroom apartments, and then 1 1-bedroom apartment. Is that what I'm seeing on the site plan?
That's right.
So I do think that they meet most of the requirements that are laid forth in variance number 2. We have no objection to the tandem parking. I think that it's great that they're supplying the 4 parking spots. There is a possibility that maybe all 4 won't even be needed, as some people may be utilizing other modes of transportation besides a car, which of course city planning is very much in favor of. And it's been our policies to reduce parking requirements. So we would recommend approval of this application, but we would highly recommend that you meet with Ohio City before pulling your permits.
Okay.
All right, thank you. Board, any questions?
I have a question, Madam Chair.
Yes.
Are all 4 of the units being used as long-term rentals, or any of them planned to be used as short-term rentals or Airbnbs?
All planning for no Airbnbs.
All 4 will be Airbnbs? Sorry,
No,
I missed that.
there's no Airbnbs there.
He said no Airbnbs.
Got it. Thank you.
Good question.
Madam Chair, is the property occupied now or empty?
It's not occupied at this time.
Thank you.
Any other questions, board?
Hearing no questions or further comments, Madam Chair. We've heard from city planning on this, and we all recommend that the appellants meet with the CDC. Should this motion pass, we'll make that a condition that they meet with them, and we have a letter from the CDC noting that before we go ahead and ratify the variance. And we've noted that the parking situation is 2 tandem parking lots, as Mr. Ruland's noted. and that the appellant noted that there will be no use of any of the apartments for Airbnbs. So with that being said, I move that we go ahead and approve calendar number 23-008.
Thank you. Can I have a second, please?
Member Brown, I second.
Ms. Brown with the second. Go ahead, call the roll.
Thank you, Madam Chair. I guess my question would be that, are we going to hold this then until we receive a letter, or are we just going to put the condition in there and allow them to move forward with their permit?
Yeah, I think we'll hold ratification until they have, the one meeting. So, Mr. Bronson, you guys make sure you talk to Mr. Lowell at House City so you can meet with them as soon as possible, so you won't hold up your project.
Lou, thank you.
Thank you.
Okay. Ms. Holzer,
Yes.
Ms. Brown,
Yes.
Ms. Roca,
Yes.
Ms. Faith,
Yes.
Ms. Britt.
Yes.
Calendar number 23-008 is granted conditionally. We will hold ratification until we receive some written documentation regarding the meeting to be held between the appellant and Ohio City, Inc. Once we receive that, we will ratify the case the following Monday, and we will send the appellant a letter.
Thank you.
Thank you.
All right, moving on.
Madam Chair, I think we are now at the beginning of the agenda.
All right.
So I imagine similarly to last week, I'll read the administrative appeal first and then the subsequent case. Okay. So next we have calendar number 23-014. This is an administrative appeal. Lutheran Metropolitan Ministry is appealing the decision of the zoning administrator in building and housing. Lutheran Metropolitan Ministry appeals under the authority of section 76-6 of the Charter of the City of Cleveland and section 329.02D of the Cleveland Codified Ordinances from the determination in site/zoning application B22009273 and subsequent notice of nonconformance adjudicated by zoning administrator Richard Riccardi on May 13th, 2022. And with that, I will hand it over to Ms. Brown for the oath.
Ms. Brown?
I am muted. Thank you. I'm here. I'm swearing in all who are present for this case, the administrative appeal. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply, I do, then state your name and address, please.
I do. Jeffrey Holmes, 3806 Franklin Boulevard.
Benjamin Ochner, 3733 Park East Drive.
You repeat your name?
I do.
What's your name again, sir?
Benjamin Ochner, O-C-K-N-E-R.
I do. Alan Weinstein, 211 Stonebrook Oval, Orange Village, Ohio.
I do. Maria. Go ahead, Kai. I do. Kai Cotton, 12003 Browning Avenue, Cleveland, Ohio. Do. Maria Fosha, 4515 Superior Avenue, Cleveland, Ohio.
I do. Dolores
Do
Garcia.
I do. Dolores Garcia, 3812 Franklin Boulevard.
Do. Angela Durazio, 2475 East 22nd Street, Cleveland, Ohio.
I do. Ron O'Leary, 4110 Franklin Boulevard, Cleveland, Ohio.
I do. Brian Rockus, 3812 Franklin Boulevard, Cleveland, Ohio.
I do. Nate Law, 3308 Lorraine Avenue.
I do. Margaret Mysack, 3018 Clinton Avenue, Cleveland, Ohio.
I do. Janine Malone, 4003 Franklin Boulevard.
I do. Robert Shank, 3901 Franklin Boulevard, Ohio, 44113.
I do. Celine Shank, 3901 Franklin Boulevard, Cleveland, Ohio.
I do. Patrick McCoska, 1731 West 32nd Street, Cleveland.
Okay, Madam Chair.
Okay, before we move forward, I think because we had a situation like this similar to last week, that the actual appeal to the city is between the actual appellant and the city. So everyone else doesn't really have standing in this, and it'll be, your testimony be taken for the next case. So I just want to make sure that, Ms. Roca, isn't that what we did last week?
Yes, that's correct, Madam Chair.
Okay.
And I just want to reflect for the court reporter that I am recusing myself from this calendar number as well as the subsequent calendar for Lutheran Metropolitan Ministry.
Yes, that's why I wanted to make sure I got your okay before you left. So, all right. So yes, if you do not work for Lutheran Metropolitan Ministry, you will be called upon for the next case. But this, for the appeal of the administrative hearing, will just be between the appellant and the city. Okay. All right, legal standard, go ahead.
Madam Chair, members of the board, appellant is appealing an administrative decision of the zoning administrator. The standard of review to be applied is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. If the appellant fails to meet this burden, the administrative decision must be affirmed.
Thank you. Okay, who will be the spokesperson for this case?
Madam Chair, my name is Ben Ochner with Burns, Ochner and Greenberger. I'll be the spokesperson, but I do have witnesses that I think it's that I'd like the board to hear from as well.
If they're for your case, okay, that's fine.
Yes.
Okay, go ahead.
Okay, thanks. The matter concerns a youth drop-in center that LMM, Lutheran Metropolitan Ministry, is going to operate at 4100 Franklin Boulevard, which it owns. The building was built in 1965, and since that time it's been used for charitable, social, and family services. It has been operated by a charitable institution, namely LMM and its related entities. Dating back to 1965, it was Lutheran Children and Family Services. It then became known as a change of name to Lutheran Family Services. And then most recently, Lutheran Family Services was merged into LMM. First, there is a certificate of occupancy that was issued to Lutheran Family Services in 2009, and that is in the documents that have been submitted. The certificate of occupancy and a printout from the online permit portal indicate that the COO was issued for Lutheran Family Services and office use. We are the successor to Lutheran Family Services. We are the beneficiaries, therefore, of the certificate of occupancy. And we think that really that's where this begins and ends. In addition, the primary purpose of this building has always been the provision of charitable, family, and social services, and that will remain the primary focus. going forward. I have several witnesses today who I'd like you to hear from. One is Kai Cotton. Ms. Cotton is the chief navigator at A Place for Me, which is affiliated with the YWCA. Ms. Cotton will be talking about the need for this type of center and her experience. Then you'll hear from Maria Fosha about prior uses and the intended use. And then you'll hear from Angela DeRazio. Ms. DeRazio is intimately familiar with the operation of A Place for Me and with the planning and the planning of this project. And she will share with you what the experience of A Place for Me has been, and how it indicates that it's a good metric to anticipate what will come next. And finally, I have asked Professor Emeritus Alan Weinstein to provide an expert opinion on planning, the planning principles and aspects of the use, through the spectrum of the zoning code and other materials that I've provided to him, and also to explain why, if it's not a permitted use, which we believe it is, why it should be approved as a variance or special permit. I apologize for being lengthy. Before I say anything else, I'm going to introduce Kai Cotton and ask her if she can provide us.
Okay, and I'm gonna, at the interest of time, because we have another case and we have a lot of testimony for these cases this morning, so I'm gonna ask everyone to be brief and to please keep your comments to what you're here for the appeal of the administrative decision. So I'm gonna ask that up front, but if I do feel like you're going too long, I will ask you to wrap it up. So just warning you now. Okay, go ahead, Ms. Cotton.
Thank you. I did prepare a testimony to speak to the need of this development. And just to be clear, I'm the lead youth navigator at A Place for Me and the chair of our youth action board, who in conjunction with the young adults on the core planning team chose LMM as our operator for the drop-in center. My testimony just talks about, again, the need of this development. So a short time after I aged out of foster care, I fell into homelessness and was subject to navigating the streets because I was a young adult and really didn't know anyone else in my situation. So for a long time led me to not have the help that I could have had. And for the last 4 years, my role has been to partner with young adults that are in need of housing navigation, exposure to resources, and other varieties of support on a daily basis. I work with these young adults, and they're all hard workers, college students, parents, creatives, and people who are just basically chasing their dreams. And most of them are focused on much more than their current barriers of dealing with homelessness or housing instability, but simultaneously just trying to cross the roadblocks and figure out what adulthood is. Unfortunately, because they lack certain assets, they are assumed a threat to certain people who have more than them. And some people speculate that individuals experiencing homelessness engage in criminal activity at higher levels than average to survive, when national evidence leads us to the fact that people experiencing homelessness are overwhelmingly more likely to be victims of crimes than renters and homeowners. And the majority of the youth that I partner with are not criminals, and I have yet to be threatened by any of them. In 2016, the Coalition of Juvenile Justice cited that youth may engage in certain survival crimes, such as theft, to obtain food, or something like trespassing themselves, and the drop-in center will be a sanctuary to young adults to lessen the chances of those survival methods being carried out. Lastly, the drop-in center will be an opportunity for the youth that have needs to come and just get them met, so that they are exiting the center with what they need and a plan to move forward, just as they do currently with my navigation, but just this time around in this center, there will be more to offer to them. Drop-in centers are proven. I'm sorry, the light went out of here. Drop-in centers are proven to help lower the chances of people experiencing homelessness to sleep in the streets and having to use survival methods in order to meet their needs. In my last 4 years of navigation, it's just really been life-changing because I've been able to use my own lived experience battling homelessness and housing instability to relate and build trust among the youth that I serve. And our top priority is safety and service. And the young adults with lived experience on the REACH board have worked for years developing a vision for the drop-in center, and 4100 was chosen by us. Thank you. We are the experts in what we need. And that includes access to transportation, the services, what spaces are comforting rather than triggering for us. And I hope that the thought of us getting our needs met at this address can cease to be a trigger for neighbors who haven't experienced us yet. And the use of this center can be approved by the board today, as LMM and 4100 again was chosen by us as an appropriate place to come and get help and move on. Thank you.
Thank you. Okay, who's next?
Morning, Maria Fosha, President and CEO of Lutheran Metropolitan Ministry. As you may know, LMM has provided social services on a charitable nonprofit basis for more than 50 years, serving those who are oppressed, forgotten, and hurting in our community. At any time, we have met that moment of needs in the community, and we have 30 years experience, particularly serving young people through shelter housing and prevention strategies. During the pandemic, LMM led a community-wide response to the COVID-19 pandemic to ensure that all persons of all ages experiencing homelessness were not further marginalized, but instead taken care of. Our mission imperative requires us to meet this moment, the solution of the Youth Drop-In Center. The building at 4100 Franklin was constructed in 1965. Since then, it has been used by LMM and its predecessor sister organizations to provide charitable, social, and family services.
I'm sorry, I need to interrupt just for a second. This seems more geared toward the next case, so you need to just keep the testimony to the appeal of the administrative decision right now, and you can save some of that stuff for, for the next case.
Okay,
I need to hear more. I need to hear more about the appeal of the. I'm not hearing that yet, so I need to hear more about the appeal of the administrative decision.
And Madam Chair, this is Liz.
Yes.
Also, we have Mr. Riccardi online. I believe that he's prepared to
Yeah, I know.
Yeah, so
I just want all of them to get whatever they need to say first before I called on Mr. Riccardi.
Okay.
But yeah, but I just need, a lot of this is kind of sounding like what we need to hear for the variance case. So just make sure that your testimony is geared toward why you want to appeal the administrative decision.
Okay, I'm sorry, Madam Chair, I think our attorney has his hand up.
Go ahead. Go ahead, Mr. Ochner.
You're mute.
Can't hear you.
Sorry about that. Thank you, Madam Chair. Very briefly, what the information that we are providing relates to the existing, the prior use. And that is germane because, as I mentioned, there is a zoning on file, and because the zoning administrator has pointed out that we have a legal non-conforming charitable institution use. And so that's why I believe that this information is relevant. Thank you.
Thanks. So Madam Chair, if I could speak to the use and the proposed use, if
Yes,
that's in line with this part. Okay.
Yes.
Thank you. So Lutheran, as we mentioned, Lutheran Children's Aid Society and Lutheran Family Services are the predecessors to LMM. Both organizations supported children, youth, and families by offering domestic adoption services, support for foster parents, and parenting classes, mental health counseling, community events. There was also office space for service partners, such as the Community Land Trust, the Lutheran Chaplaincy, and offices leased to a few professionals. Even LMM's early offices were at the site. The principal focus of those services were for charitable, social, and family services. Again, behavioral health, case management, benefits assistance, counseling, education, and support. Space for nonprofit service partners. LMM occupies the office space as well as professionals who are tenants. LMM even held a drive-through holiday food drive during the pandemic years. What goes hand in hand with behavioral health, case management, and counseling is assisting people with basic needs. That may be a snack, clean clothes, hygiene products, or a bus pass. Any social service provider would affirm this, and certainly given our 50-year experience, we can also affirm this. The nature of the services provide for an in and out flow to the building and flexible business hours. It's been the norm that small groups, as well as others, have used the site, so anywhere from 4 to 6 people, upwards of 20 at any given time. The use has varied over the years. The office space has been available even when the charitable, social, and family services were closed for the day, and that's up until the pandemic. That was the nature of the use. The pandemic significantly impacted operations at this site as the community closed down. This is one of LMM's sites that became less utilized, though it remained in use throughout the period. With the potential use of the site for the Youth Drop-In Center identified late in 2021, we kept that usage low, holding out with the hope that this would be the location for the site of the Youth Drop-In Center. The Youth Drop-In Center itself will focus on LMM's customary charitable and social family services and our energy on a vulnerable population of young people, ages 16 to 24, who are experiencing homelessness or housing instability. The center was co-created with a team of young adults who have lived experience in homelessness. The center's primary objectives include providing a peaceful, safe, and secure environment for respite, forming relationships, and providing customary services. It will be a resource hub meeting basic needs such as food, clean clothing, personal hygiene, bus passes, computer access, internet, phone charging, and housing services and supports, benefits, case management, and behavioral health services provided by LMM, a place for me, and co-located partners such as NEOC. We've agreed that we will not operate 24/7 based on neighbor and councilman feedback. In addition, the hours will be up to 10 hours per day, 7 days per week. In this case, as in all others, young people with lived expertise were the final decision makers on this choice. At any given time, we expect up to 12 to 15 youth in the building to serve about 200 youth in the first year and between 5 to 12 staff on site. We acknowledge that this will be more people at the center than currently, but it is similar to the pre-pandemic numbers. We anticipate a narrower focus of LMM's charitable social services for homeless youth and young adults. It will take some time to build up those pre-pandemic numbers. Finally, safety is incredibly important to us, young people in the neighborhood. The drop-in center will include outside security cameras, new fencing, and locking gates. It will include specially trained safety personnel. These measures may enhance neighborhood safety. LMM, like most social service providers and public buildings such as libraries and rec centers, has safety protocols in place and a no weapons policy. We are proposing what is standard practice. In closing, I know we are here to state the facts. I hope I provided that for the board. From a humanities standpoint, I would say that we are at a pivotal moment as a community struggling to address homelessness, anti-LGBTQ sentiment, and racial tensions. Together, we have the opportunity to choose to listen to young people with lived experience who represent these struggles and provide resources for them to thrive. So I hope we can come together and meet this moment. Thank you.
Thank you. Next.
Madam Chair, may I ask Ms. Fosha one question as a follow-up?
Yes.
Thank you. Ms. Fosha, can you tell us who the expected guests and users of the drop-in center will be?
Yes, most of our guests who come to the Youth Drop-In Center are racial minorities, those that identify as LGBTQ. So this is an important resource for them.
Thank you. Next, Madam Chair, I asked Angela D'Orazio to provide information.
Thank you. Good morning. My name is Angela Durazio, and I have the honor of serving as the Senior Program Officer for Housing at the Sisters of Charity Foundation of Cleveland. In 2014, the foundation partnered with the National Annie E. Casey Foundation to create A Place for Me, a community initiative focused on preventing and ending homelessness among young people ages 16 to 24. As chair of the board, I am also here representing A Place for Me and its network of public and private partners working together to end youth homelessness in Cuyahoga County. Since its founding, A Place for Me has intentionally centered the expertise of young people who have experienced homelessness, creating the Reach Youth Action Board in 2016 as a dynamic group of young leaders who advocate for meaningful solutions to youth homelessness in our community. As you heard from Kai, young people with lived experience are the experts in this work. They direct and inform the development of solutions in ways that none of us without their lived expertise can. Not only did young people identify the need for the Youth Drop-In Center, but they shaped it, including its proposed location, its design, its services, and operations. Nearly 1/3 of the more than 500 young people who seek emergency housing services annually through our county's coordinated intake system do not follow up on the shelter referral they receive. Even among those who do come to shelter, many young people disengage within days, leave shelter, and essentially become lost to the system. The Youth Drop-In Center will fill a critical gap in outreach, engagement, and services for young people experiencing homelessness in our community. Young people here and across the country have said clearly that emergency shelter is often not what they want or need. A youth drop-in center like the one we propose honors young people's lived experience and their hopes for a better response to the trauma of housing instability. A 2008 study led by Dr. Natasha Slesnik notes the importance of not only physical accessibility of a drop-in center, but also social and emotional accessibility. A sense of safety is critical to ensuring that young people will make use of the center. Citing the center at 4100 Franklin Boulevard in a neighborhood with a healthy mix of residences, social services, churches, and other community-based amenities was an intentional decision made by the experts, young leaders with lived experience. As Kai noted in her remarks, young people using the center will come there by choice to access a safe place and connect with services to advance toward a more stable future. Through A Place for Me's decade of work with this demographic, there has been no criminal activity among clients seeking help. This is a credit to the trust that A Place for Me instills and the safety that young people feel in having their needs met. Ultimately, we believe that meeting people with dignity and responsiveness, coupled with the common sense safety measures that Maria spoke of, is the best approach to ensuring the safety of guests at the center and community members in the surrounding neighborhood. As a lead funder in this effort, we are committed to supporting the Drop-In Center to be a good neighbor in the community. We are grateful for the overwhelming support and welcome we have found in Ohio City, including the support of the Franklin Clinton Block Club and Councilman Kerry McCormick. Thank you.
Okay, next.
Next is Professor Alan Weinstein. His report and curriculum vitae were attached to a supplement to the notice of appeal that I've submitted on, I think, Friday. I'd like him to just address those components of the report that relate to the issue of the appeal, namely that this is
this is we got all this beforehand, and the board has read everything that was submitted to us beforehand. So please just keep this, because up until this point no one has. So please keep this to the administrative appeal, please.
Thank you.
Thank you, Madam Chair, and please, I'm sure you won't hesitate to inform me if I am going away from addressing that topic. Just very briefly, I know you have my report in front of you, just for the benefit of other individuals who are involved here. My qualifications are that I have been a professor of law, professor of city planning for over 40 years. I now have emeritus status. I have a master's of city planning degree from MIT and a JD from the University of California, Berkeley. I also have over 40 years of experience consulting on planning matters for both local governments and private parties, and I'm the co-author of the one-volume treatise titled Ohio Planning and Zoning Law. As regards the administrative appeal, the first point I want to make is that in my professional opinion, there has been no change of use in the LLM's use of the property. It has been used to offer various services to needy populations as part of the charitable mission of LLM. The only thing that has changed is that the population being served will no longer be the general population, but will be the population that was previously described involving homeless youth. As regards the issue of should this be seen as a substitution or change of use, I think that the proposed use meets the standards for grant of a special permit. I won't address in-floor or other space occupied because that really is more properly addressed in the next hearing. In terms of volume of trade or production, as I said before, there is no change here. The only change is in the population. Kinds of goods sold or produced, there are no goods or sold or produced at this location. Daily hours or other period of use, while the hours are going to increase from those that had prevailed in recent years due to the pandemic, this is merely a return to the hours that were prevalent during the post-pandemic years and for many years. In terms of the type or number of persons to occupy or to be attracted to the premises, again, compared to prior use pre-pandemic, there is no change in number of persons who are going to be attracted. The category of type of persons is, as my report notes, very problematic from a planning and zoning standpoint, and zoning with very limited exceptions does not consider the type of person as a relevant zoning or planning criterion for judgment. Finally, the last is any other characteristic of the new use as compared to the prior use. In my professional opinion, really nothing has changed. There are some minor services that will be added, but these do not change the fundamental use that is proposed as compared to the previous use. Thank you.
Thank you.
Madam Chair, the one thing that I have not seen on the PowerPoint is the zoning certificate that was issued in August of 2009. It's a two-page document. The first is the actual certificate, and the second is the download from the permits portal showing that the zoning certificate was issued for Lutheran Family Services and for office use. And I think it might be helpful for the board to see that, since we are maintaining that our use is well within the scope of the charitable institutional uses that for which Lutheran Family Services was approved. And in fact, on a corporate basis, we are Lutheran Family Services. I'm happy to provide additional legal argument if and when you think that's appropriate. Otherwise, we're happy to answer any questions.
Great, thank you. So board, do you want to hear from Mr. Riccardi first and then have questions, or do you want to have questions for the appellant right now?
I'd like to hear from Mr. Riccardi, please.
Okay. All right, Mr. Riccardi, go ahead.
Thank you, Madam Chairman. You don't have an exhaustive presentation or witnesses. It's just a very concise presentation or explanation as to why a Board of Zoning Appeals hearing is required pursuant to the Cleveland Zoning Code for this activity at this charitable institution in the two-family district. And I won't read all of this, but some of it just stating in determining the zoning analysis regarding the applicability of the constitution of a change or expansion of a non-conforming use per section 35901, the initial threshold is a determination of whether the existing use is non-conforming. The current use, as shown by council, was established in 2009 for Lutheran Family Services and private offices for 20 people. And applying the code most favorable to the property owner, the use is most similar to a charitable institution. And these charitable institutions are permitted in residential districts with conditions. The 1 and 2 family districts, of course, are the most restrictive districts in the city of Cleveland and in the Cleveland zoning code and planning scheme. It's permitted provided that it's at least 30 feet away from adjoining premises and requires the Cleveland Board of Zoning Appeals approval to determine, and the language is there, after public notice and public hearing, if adequate yard spaces and other safeguards to preserve the character of the neighborhood are provided. And if in the judgment of the board, such buildings and uses are appropriately located and designed and will meet a community need without adversely affecting the neighborhood. You remember, these are large institutions that are permitted in residential districts. And so you see in the zoning code, there were the safeguards that at least there would be a hearing to determine the impact on the residential districts. And that's really what we're here for today, is to determine whether or not there's going to be a hearing, or whether this is just, this change in activity is permitted as of right. The existing facility is not at least 30 feet away from adjoining premises and is therefore a non-conforming use. I don't think the distance is at issue here. And then after that threshold determination of nonconformity, the issue is whether the new or additional activity constitutes a change or expansion of the nonconforming use. And I won't get into a description of the use here. We've already heard a lot of testimony about the new prospective activity and the thorough planning, the research, the blog site that I have referenced there talks about kind of an exhaustive search for the right facility for the new activity. And it also states that it will be the first use of its kind in Cuyahoga County. And we've heard that. So when the city staff conducting the zoning analysis reviewed the application and that prospective use or activity in the context of 35901, and it's cited there. I won't read all of it. It basically states that a non-conforming use, but a legally established non-conforming use, can be continued, but no enlargement or expansion shall be permitted except as a variance under Chapter 329, and no substitution or change in the non-conforming use shall be permitted except by special permit from the Board of Zoning Appeals. And the Board of Zoning Appeals, in holding their public hearing, has to determine whether the substitution or other change is not more harmful or objectionable than the previous non-conforming use in floor or other space occupied volume of trade or production, kind of gold sold or produced, daily hours or period of use, in the type or number of persons to occupy or to be attracted to the premises, excuse me, or in any other characteristic of the new use as compared with the previous use. Now, there is interior renovations to the building, and an apparent different use or occupation of the existing floor space will occur. The daily hours and the period of use are changing. Pre-pandemic, at one point or another, it would be difficult to determine the exact pre-pandemic that they're talking about, but it has been acknowledged that the hours are changing, and a difference or alteration in the type or numbers of persons to occupy or to be attracted to the premises. And when you say the different type or numbers of persons, this is the zoning code language we have that we, as city staff, we have to deal with. Now, we know that the different clientele served is the main focus of the youth drop-in center. For this reason, the determination was made that the new proposed activity constitutes a change or expansion of the existing use and activity at the facility, and that 35901 requires the Board of Zoning public hearing and approval. And I think you have to look at it when you talk about the type of services that were offered by the Lutheran ministry. I think you have to look at it as perhaps a good analogy would be a restaurant that wants to add something that's common to a restaurant, such as a drive-through. If that restaurant is in a retail business district, it can add that activity that's common to restaurants and would be a part of that. It would be a new activity, but it'd be an activity common to restaurants. But if that restaurant happened to be a non-conforming use in a residential district, adding that drive-through would require the same public hearing before the Board of Zoning Appeals that's being held here. There's a strong intent and indication of at least an examination of the impact of the non-conforming use new activity to the residential district when it's non-conforming. And those are just the issues that we have to deal with in reviewing and determining that the public hearing, the BZA hearing, is required. Thank you.
Thank you, Mr. Riccardi. Okay, I'll open it up to my board now for questions for either the appellant and or Mr. Riccardi.
Well, I found the analogy about the drive-through very enlightening. So I appreciate that comment. And also the expansion or increased intensity of use also seems to indicate a need for a hearing.
Any other questions or comments, board? Ms. Knockner, did you have your hand up?
Thank you. Couple of things. There's no dispute that this is a charitable institution and that it is being used for purposes offered by charitable institutions. Your zoning code in this district says charitable institutions other than for correctional purposes. Elsewhere in the code, in, for example, the industrial district, you have charitable institutions, including for correctional purposes. So there's a distinction of great importance to us is that in defining, well, charitable institution itself is not defined in the code. And the question then becomes, is what LMM has done and intends to continue to do within the scope of services that are commonly understood as the services provided by a charitable institution. As we've demonstrated in the supplement to our notice of appeal, of course that's the case, and based on Ms. Foch's testimony. Of course, what we're continuing to do with a narrowing of our focus on just young homeless people is clearly a charitable use. There is not a change in the existing type of persons, and again, I can't understand why that language would be in your code, but it invites consideration of the fact that there is a vulnerable group of people who, because they are who they are, somehow aren't deserving of the zoning administrator or the Board of Zoning Appeals favor. I don't think that that's it's intentional. That's part of it, but I think that I was surprised to hear Mr. Riccardi emphasize that. I have to say that the analogy to a drive-through does not work, because what we're talking about is what's in your zoning code, and by implication, what's not in your zoning code. If it's a charitable institution, it is a permitted use so long as it's not correctional purposes. It is a charitable use. There's no dispute about that. I still haven't seen the certificate of occupancy. If you showed it, I missed it. I never saw. Pardon?
The point is the 30 feet, not what you're talking about. That's what I thought I gained from Mr. Riccardi's comment. And then once you got past the 30 feet, it was the number, not just type. I don't think anybody is addressing that, but the number of people and the hours of operation. So Mr. Ochner, and I'm sorry, Madam Chair, I'm really hoping to get to the actual variance. But
Yeah.
Are you, sir, saying because it's a charitable institution, no matter what they do and where they are anywhere in the city, they just can do it?
No, if they're in a district where charitable institutions are permitted, and the zoning administrator has stated that this is a legal non-conforming charitable institution. I don't know what was non-conforming about it, but if it's the 30-foot distance, then that's already been taken into account. We have a zoning certificate, a certificate of occupancy. And so the fact that we're 30 feet away, we've always been 30 feet away. The building was built in 1965. It was less than 30 feet away. It has provided charitable institutional uses since 1965, less than 30 feet away. That distance is, frankly, it's irrelevant, because we have both legal non-conforming use and we have a certificate of occupancy. There has been no change in the use other than, no change in that our use is a charitable institutional use, and it is offering charitable family and social services. So I'm not trying to offend anyone And but I do find the reliance on the language in the code that seems to allow a distinction based on the fact that these are homeless people that are going to be coming for services is problematic. Again, we are the successor in interest, and this is indicated on some corporate documents that I forwarded to Ms. Kukla at the end of January, indicating that Lutheran Family Services, which one of the uses for which the certificate of occupancy was issued, has been merged into into LMM, and there's no reason apart from a lot of very upset, angry neighbors who have a presumption about what's going to happen that is unsupported by the evidence, that we're going through this. I don't think, with great respect for the board, I don't think this is within your purview now, because we are a continuation of either a conforming legal use as evidenced by the certificate of occupancy, which doesn't differentiate different kinds of uses that are authorized, or because we are a legal non-conforming charitable institution use. And I'd like Mr. Weinstein to weigh in if he may.
I'm just going to make one very brief comment on Mr. Ricciardi's point that because this is now going to be serving homeless youth, it requires it's a change. And the comment is, if LMM announced that it was only going to serve individuals 65 years of age or older, as opposed to the general population, or if it was only going to serve single female parents, as opposed to the general population, or it was only going to serve refugees and asylum seekers, as opposed to the general population. By Mr. Ricciardi's logic, any change in the population sought to be served by this charitable institution would require a hearing and another approval. And that focus on the individuals who are the clients of the charitable institution is not properly, in my professional opinion, is not properly a concern of planning and zoning.
Well, I'm sure I missed something, and I didn't take that Mr. Riccardi was focusing on as much the type, meaning homeless, of people versus the number, the types of service, and the operations. So, Mr. Riccardi, would you like to, I'm sorry, Madam Chair, but I feel like they're arguing a different point than was made.
Yeah, Mr. Riccardi, did you want to rebut anything?
For the record, is the characterization that I had stated homeless youth as a type of persons. I know we don't have the benefit of a transcript here, but you will not find me saying that term. So I would appreciate not being characterized like that. I said that we are bound by the language in the zoning code in reviewing this. Common and in the terms of in city staff in reviewing, well, I'm not going to say any more except that you won't see that in my statement, in either the written statement, or if it does ever become transcribed. So I would appreciate not using the negative connotations to characterize my testimony. Thank you.
Madam Chair.
Thank you, Mr. Riccardi.
Madam Chair, Mr. Riccardi used the expression a major major change in clientele. Plus, the board and Mr. Riccardi know what this intended purpose is. I'm not trying to accuse Mr. Riccardi of anything other than what I've said, which is using this provision of the code as a basis for a determination as to our land use.
Okay.
Okay.
I understand. Yeah,
Madam
we need
Chair, may
to.
I ask a question? Because now I'm confused.
Okay, go ahead, Ms. Brown.
All right, so this is to Mr. Riccardi. And it's not about type of people. If in fact, as Mr. Ochner talks about, that the siting of the building less than 30 feet away from residential use, I assume, has been established and permits were granted, your non-conformance and the recommendation for a hearing and the variances is based primarily on what?
I think
You're
that,
on mute, sir.
can you hear me now?
Yes, sir.
Yes. I think one of your earlier statements, when you asked, because you are a legal, albeit non-conforming charitable institution, that you can do anything, and you can't. This is the change in activity, the change in the type of in the occupation of the floor space, the change in the hours. It all relates to this being a charitable institution that is non-conforming, and that it's too close to it's too close to the adjoining premises or the lot line in a residential district. Because you received a certificate of occupancy 15 years ago, it's not a free rein to do these types of things that are cited in 35901. By these types of things, I mean the things that are potentially expansions or substitutions or changes in use. So yes, the 30 feet is an area standard, but it's too close. And you also have to remember that's only one of the two conditions to this being a non-conforming use. The other condition is that that general review of the Board of Zoning Appeals about the public notice, public hearing, adequate yard spaces, other safeguards, preserving the character of the neighborhood are provided. The judgment of the board, the building is appropriately located and designed, will meet a community need without adversely affecting the neighborhood. That's a second condition that affects potential substitutions, expansions, changes in use.
Ms. Brown, does that answer your question?
It does. Thank you.
Madam Chair.
Are you saying, are you saying something new, Mr. Ochner?
Yeah, I am. I'm sorry, Madam Chair. Yes, I am. This idea that if we make any change to the interior, we have to go back before the Board of Zoning Appeals has absolutely no support in your code or in logic for that matter. We're 30 feet away from a property line, which has been the case since 1965.
We understand that fact, yes.
So the issue is whether or not we are continuing a charitable institution. We are. There's no question about that. The hours we've talked about, the type of person we don't need to. And beyond that, and the increased traffic, it's going to be, I think that the zoning certificate, the second page of the zoning certificate indicates 20-person occupancy upstairs and on the first floor. That's 40 people. The information you have is, or should have, is that it's going to be 12 to 15 people at a time with upwards of maybe 15 staff members. So whatever occupancy there is, there's no standard in the code that says how many people can visit a charitable institution. And that's not the kind of thing that can be imposed on an ad hoc basis. So there's no reason for us to be going through a hearing on variances and special permits, because this is already permitted. Thank you.
Thank you. I'll let Mr. Riccardi respond, and then I'll open up to my board for any more questions.
Thank you, Madam Chair. And
we're
just
ending
once again,
testimony.
thank you, Madam Chair. And just once again, I would ask not to characterize my testimony. I didn't say any change at all would have to come back to this board, but definitely changes that that are arguably or reasonably would meet some or one or any of the conditions in section 35901 that I've already read. And I think this is a case where clearly it does. Without commenting on because we haven't gotten into the actual substance part of a potential variance or a potential hearing where the standards are considered by the board. But just remember, this is just the threshold determination that the zoning hearing is required. And so once again, it's not any change. It's changes that are listed in section 35901. Thank you.
Thank you. Okay. Board, do you have any other questions for the appellant and or Mr. Riccardi? Hearing none, I will entertain a motion.
Madam Chair, hearing no further comments or questions, we are I'm going to make a motion with regard to calendar number 23-014. We've heard testimony from Mr. Riccardi and from the LLM team. So this is for the appeal of the decision of the administrator. And with all that in mind, I would move that we uphold the decision.
Thank you. Can I have a second, please? Somebody muted.
Member Brown, I second.
Ms. Brown with the second. Go ahead, call the roll.
Ms. Holzer,
Yes.
Ms. Brown,
Yes.
Ms. Faith,
Yes.
Ms. Britt.
Yes.
Calendar number 23-014 is denied if the decision of the zoning administrator has been upheld. We will ratify this next week and we'll send the appellant a letter.
Great. Moving on to the next case, which is the same case. Go ahead, Ms. Holzer.
And as with last week, would you like me to read the entire thing, all of the sections?
Yes, please.
Okay.
Yes.
Our next case is calendar number 22-213. This is at 4100 Franklin Boulevard. Lutheran Child Aid Society owner proposes to renovate an existing legal nonconforming charitable institution to add use as a drop-in care center for teens and adults, and to expand hours of operation in a B1 two-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 3. First, there is sections 337.03B and 337.02G, which state that a charitable institution in a two-family residential district must be at least 30 feet away from adjoining premises and requires review and approval by the Board of Zoning Appeals after public notice and public hearing to determine if adequate yard space and other safeguards to preserve the character of the neighborhood are provided, and if in judgment of the board, such buildings and uses are appropriately located and designed and will meet a community need without adversely affecting the neighborhood. The proposed use is not 30 feet from the adjoining premises. Next, we have sections 349.01A, which states a use of building or land for which a permit has been lawfully issued may be continued even though such use does not conform to the provisions of this zoning code for the use district in which it is located. But no enlargement or expansion shall be permitted except as a variance under the terms of Chapter 329, and no substitution or other change in such non-conforming use to other than a conforming use shall be permitted except by special permit from the Board of Zoning Appeals. Such special permit may be issued if the board finds after public hearing that such substitution or other change is no more harmful or objectionable than the previous non-conforming use in floor or other space occupied, in volume of trade or production, in kind of goods sold or produce, in daily hours or other periods of use, in the type or number of persons to occupy or to be attracted to the premises, or in any other characteristic of the new use as compared with the previous use. And finally, we have section 341.02, which states approval of the Cleveland Landmarks Commission being required. And with that, I will hand it over to Ms. Brown for the oath.
Go ahead, get some water, Ms. Holzer. That was a lot to read.
All right, so I am swearing in all who are present and choose to speak on this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply I do, state your name and your address, please.
I do. Benjamin Hochner, 3733 Park East Drive, East.
I do. Kai Cotton, 12003 Browning Avenue, Cleveland, Ohio.
Do Maria Fosha, 4515 Superior Avenue, Cleveland, Ohio.
I do. Alan Weinstein, 211 Stonebrook Oval, Orange Village, Ohio.
I do. Ron O'Leary, 4110 Franklin Boulevard, Cleveland, Ohio.
I do. Dolores Garcia, 3812 Franklin Boulevard, Cleveland, Ohio.
I do. March Mysak, 3018 Clinton Avenue, Cleveland, Ohio.
I do. Brian Rockus, 3812 Franklin Boulevard.
I do. Nate Lull, 3308 Lorraine Avenue.
I do. Jeff Holmes, 3806 Franklin Boulevard.
I do. Janine Malone, 4003 Franklin Boulevard.
I do. Celine Shank, 3901 Franklin Boulevard.
I do. Patrick McCoska, 1731 West 32nd Street.
I do. Robert Shank, 3901 Franklin Boulevard.
I do. Angela Durazio, 2475 East 22nd Street.
I do. Matthew Moss, Cleveland City Planning Commission.
I do. Ben Trimble, 3308 Lorraine Avenue.
Okay, Madam Chair.
Thank you. History of the property, please.
Thank you, Madam Chair. This property was originally zoned multifamily in 1929. In 1985, it was changed to the current zoning. We found very little on this address. We didn't find anything in the Records Administration Office. We did, however, note that on our Sanborn maps in our office, they're from 1920. The original structure on the property was identified as a girls' home and club room. And then in our later books, we found that in 1965, as was stated in the last case, that at some point that year, the Lutheran Center was erected at this address. And then, Madam Chair, there are no variances on file. And then in the more recent history, we did find that the 2009, the certificate of occupancy was issued stating that the use of the property is Lutheran Family Services and office for 20 people. And that's all I have. Thank you.
Thank you. Legal standard, please.
Madam Chair, members of the board, appellant is requesting a use variance from the requirements of the zoning code. To obtain the use variance, appellant must prove that denying the request will result in an unnecessary hardship particular to the property such that there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code.
Thank you. Okay, so before we get started, we have at least 12 people that want to testify today. And that means it's going to be an even longer hearing. So first of all, we have ground rules when we have a lot of testimony up front. I ask that everyone be respectful, that there are no personal attacks. I don't need to hear the full history of the neighborhood. We're here about the variances that they're asking for, so please keep your comments to the variances that are before us today. And please keep your comments brief. We do have a record, and the board has read everyone who submitted a letter for and against this project. So we do have that for the record, and we have read them. So if you did submit a letter, we have that on record, and you can definitely still testify, but just do a quick summary of the letter that you already submitted, either for or against. And if I feel like you're going off on the tangent, I will bring you back. So all that being said, Mr. Ochner, I'm sure ready to present, so go ahead.
Thank you, Madam Chair, members of the board. I'm going to jump right into the variance issue, noting my reservations of why. I will turn it over to Alan Weinstein for him to provide his planning analysis of why special permit and variances should be granted in this case.
Thank you, Ben. Since this is addressing the same issue as the previous hearing, where I did walk through the criteria for issuance of a special permit, Madam Chair, with your permission, to save time, I will. Can we agree that I do not need to go through that again?
We can agree to that. Yes.
Thank you, Madam Chair. If we turn to the variance, if we look at Chapter 329, in my professional opinion, the most critical criteria there that the BZA must consider in deciding on a variance request relate to meeting, quote, a community need without adversely affecting the neighborhood, unquote, and ensuring that the character of the neighborhood will be preserved. So the first question is, what is the character of the neighborhood? And while it's previously been stated that the 1- and 2-family districts are the most restrictive in the code, In this case, if we take a look at the neighborhood, what we see is that there are a number of more intensive uses than 1 and 2 family. And frankly, a number of uses that are far more intensive than the proposed use or the previous use of the LMM property. Just very briefly, at 3801 Franklin is the Eleanor, an almost 8,000 square foot apartment building with 8 units. At 3806 Franklin, the Stone Gables Inn, a 9,000 square foot small boutique hotel. At 4210 Franklin, St. Herman's, a 4,300 square foot building operated as a youth hostel. At 4308 Franklin, the Franklin Castle, a 7,700 square foot structure that offers overnight accommodations and tours for up to 12 visitors every Tuesday, Wednesday, and Thursday night from 5:45 to 7. At 4312 Franklin, St. Herman House, a 2,700 square foot shelter offering emergency shelter. And at 4427 Franklin, St. Paul's Community Church, which as part of its ministry has an outreach center for those in need. In addition to those uses, which are all on the block where the LMM building is located, directly across West 38th Street is Franklin Plaza at 3600 Franklin Boulevard, a 218 unit, 85,000 square foot convalescent hospital with on-site parking for more than 50 cars. The point of this is to illustrate the fact that while this is definitely a two-family district, it is a two-family district that has a mix of far more intensive residential, service, and other uses than the proposed use. And so again, in my professional opinion, the proposed use is going to meet a community need. It's already been stated that there is no drop-in center for homeless youth anywhere in Cleveland, Ohio. And in my professional opinion, it will not adversely affect the neighborhood. It is not going to change the character of the neighborhood. It is far less intensive than almost all of the uses that I just described. And that
Thank you. Great, thank you. Mr. Ochner, anyone else from your team?
Only if they have something to say. I wouldn't say any of them, but I don't have anything else other than what I've presented already by way of the notice of appeal and the supplement and the documents that we submitted.
Okay, thank you. All right, well, I'll start with the residents. Number 1, Mr. O'Leary.
Thank you, Madam Chairwoman. You've said that you have the statement that I submitted. Also, great. So I'm going to try not to go into that. But there's a couple of points that I do want to make. Ms. Fosha, and then I believe that Mr. Ochner, as the attorney, said that the decrease in use of this property has really been related to the pandemic, and I disagree with that. My family's been next door to this building for 19 years, almost 19 years. And this building, the amount of people using it, from what I've observed, has been relatively light for at least the last 10 to 12 years. There's typically no more than 1 or 2 cars in the parking lot. It's typically normal business hours, 9 to 5 or thereabout, Monday through Friday, not on weekends, with the exception of the attorney that rents space in the building. He's usually there a couple of evenings a week for a few hours, and some on the afternoons. I'm sorry. Can you see me on this?
Yes.
Yeah, we can.
Okay, I'm sorry. It must have been the orientation that I had. I apologize for that. So this building has really been lightly used with very few people, very little traffic, very little noise. for at least the last 10 to 12 years. I believe that that's about the time that they stopped using the building as an adoption agency, but I don't know that for certain. What I do know is that the decrease in the number of people at this building has not been at the drop off starting at the pandemic. It's been for much longer than that. Sorry, I'm just checking my notes again. I don't want to go over things that that are in the document I submitted. There's been some discussion about the neighbors on our block who oppose the use at this site. Couple of things there. Number one, our block between 38th Street and 44th Street is, as far as I know, completely unified in opposing this. I believe that Ms. Diorzio had mentioned that the block club had supported this using this location for the youth drop-in center. It was a close vote, but what I would say is this: the people that are most directly affected by this, the ones on the block, the ones of us that are going to be affected by the increase in noise and the traffic and the potential crime. One thing I didn't mention was garbage. We have St. Herman's down the street, and it's an almost daily occurrence that there's garbage, in our yard, in the neighbor's yard. And with this property proposing to distribute food, it's reasonably foreseeable that there's going to be an increase in garbage on the street as well. So for those of us that are directly affected by this proposal, our entire block is opposed to this. And I will say that we have repeatedly told LMM that we think this is a good program. We think that this is a needed resource for the community, but it's not the right location for it. It needs to be in an area that is, more accessible to public transit, and not in an area that's going to affect residences. My opinion is that this is probably would first be able to be located as of right in a general retail district because of the types of services that are going to be provided, and that people are coming from all over Cuyahoga County. I suspect that if there's even people coming from outside of Cuyahoga County, that LMM and its partners would serve them as well, as I think that they should. But this is just not the location for it, in a two-family residential district. So thank you all very much for hearing me.
Thank you. Okay, Ms. Garcia, Dolores.
Thank you, Madam Chairwoman, and thank you to everyone else on the board for allowing the residents an opportunity to speak with you today. My name is Dolores Garcia. I've lived at 3812 Franklin Boulevard for the last 10 years. That's one house down from the proposed location at 4100. I have 7 children, a blended family under the age of 10 that I live with. And speaking as a mother and a neighbor, I'm very concerned about the adverse effect that operating a youth drop-in center in this residential section of Ohio City would bring. LMM, like I said, I've lived here for the last 10 years, and LMM has not had the kind of significant traffic, foot traffic and car traffic to its current building that this drop-in center would bring. In addition, they have not been a good neighbor in terms of property management. This is a totally underutilized building. Even before COVID, there was very little in and out of regular staff members, except for the private parties that LMM leased office space to. They haven't had a regular and consistent enough presence to stop, unhoused people from already camping out and using. I multiple times have found seen people using the side and front of that property as a toilet. There are other aspects of the building, from the facade to the parking lot we saw in the picture. You know, the huge pooling and flooding of the parking lot. It's just not been a very well maintained building. And so I see why now Lutheran Metropolitan Ministry would jump at the chance for a $1.5 million facelift that's sourced from outside funding, much of which is public dollars, to turn this underutilized building into a revenue generating asset for a multi-million-dollar corporation. And that seems to be the driving motivation for locating the YDIC at this location, rather than being ideally suited to either serve the population that you know, has been identified as the target for service recipients, and because of the adverse effect on the neighborhood. We can't lose sight of the fact, and it's been mentioned several times, that there is not a youth drop-in center operating anywhere in Cleveland. And in fact, what they are proposing to do at 4100 is something that's completely unprecedented in the state of Ohio, and locating a youth drop-in center in an entirely residential area. And we have been frustrated by the fact that, as the immediate neighbors, that there has been no effort to really do any kind of organized assessment of what the effect on the neighborhood and the immediate neighbors would be. We heard from LMM's counsel that, you know, criticizing the immediate neighbors, saying that we have made presumptions, but that's done we have not made presumptions, but that's also been a reaction to the fact that we have not been able to get LMM to provide us any coherent study or set of data that would address this unprecedented and radical change in use on our street. They have not done the research, but that's put the onus on the neighbors to actually look into what the effect would be. And I know you've received the presentation from Robert Schenk, and under his leadership, that information has been presented to this board. There's unrebutted evidence presented there that this would have an adverse effect on the neighborhood and the immediately surrounding neighbors. You've heard from LMM that they plan on taking security measures, but those security measures are aimed entirely at securing their own building, their own facility, and their own property, and not out of any concern and not without any effect to the neighbors.
I'm sorry, we're going to disregard that statement. We can't put what your personal feelings are about LMM on the record. So that's why I was asking people up front to have no personal attacks, and to please keep your comments to the variances needed today.
And I am talking about what the effect would be on the immediately surrounding neighborhood and the street, based on what.
True. Then you started to characterize like what they're going to do and not do. So just keep it to what your perspective is.
My perspective is they've said they would do.
No attacks on that. Just keep. You were doing good. You were doing good until then. So.
Okay. I don't think they've taken any steps to address the safety concerns of the other neighbors and the effect on the surrounding property. I'll just say that. You've also heard from LMM's counsel that they believe that they can do essentially anything under their current occupancy. And I think it's important to remember the effect of the variance on the neighbors, which is that it would run with the land, not just with LMM. So even if LMM were to be a good operator, there's no guarantee that another social service organization taking over the property would operate consistently with what and how they've represented their intentions for the property. Given what we've heard from LMM's counsel, it's clear that they believe that any charitable service would be permitted, including servicing a different non-youth population, 24/7 operations, and that could even extend to shelter services or anything else essentially that they can categorize as charitable, for example, needle exchanges or other.
Okay. All right, Ms. Darcy, you got to wrap it up.
Okay, thank you. I would just ask that the board listen to the neighbors, the immediate neighbors who have put in a lot of effort, footwork, research, in trying to understand what the effect would be of opening this operation at this location. There is no way that this increased foot traffic, the different services being offered, and the radically different the radically different population that they plan to serve would not have an adverse effect on the neighbors. And so I don't believe that this meets the standard for a variance, and respectfully ask the board to deny their request. Thank you.
Thank you. Margaret Misak?
Yes, thank you very much. So my husband and I submitted a letter, so I'm not going to go into that because it was rather long, but we've lived here for 32 years, raised our children here, and I submitted a lot of information about living very close to other organizations, a girls' home, the Y Haven for ex-convicts, and those positive interactions that our family has had with services very similar to this. And I think that what I'd like to take from that is that this is a neighborhood that when it is welcoming, those kinds of interactions can be very positive. What I want to really bring to your attention and take just a couple of minutes to do, you've received another letter that was signed by 186 residents as a sign-on letter in support of this location, 4100 Franklin, as the appropriate and the choice location for the youth drop-in center. So a total of 186 individuals and organizations signed that letter through a Google Docs thing where they had to provide, valid affirmation that they were who they were. And of those 186 people, 100 live within the Franklin Clinton Block Club neighborhood, which is the block club of the drop-in center location, LMM's location that we're talking about, or within a half mile of 4100. That's 100 people of those signers. That is within a 10-minute walk or close enough to encounter that location on a daily or weekly basis. And then the other 86 signers were more than a half a mile. Most of them were within a mile of 4100 Franklin. This is a project that's been vetted for a year in our neighborhood. Community-wide meetings, 3 block club meetings, listening sessions that LMM has offered to anybody who wants to come and talk in depth. Some of the neighbors that are speaking were at those. I was at those. Multiple written materials that were disseminated, and more recently a dinner that a non-affiliated group that was attended by 54 people who were interested. So what I want to emphasize, I guess, is that the letter signers to this that are in support have taken their position with a very good knowledge, I think, of what the potential impact will be on themselves and their community and their neighborhood. They come to this with a pretty good understanding of what's been presented about what will occur at the drop-in center, and they have said, yes, we want this in our neighborhood. So from their perspective, from our perspective, because I'm a letter signer, what do we think the impact's going to be? Well, for one, the building and the property that's around it, we think are very appropriately sized for the scale of the operation that's being proposed. The parking, often there's parking issues in this neighborhood. That's not an issue here. The size of the building for who's going to occupy it during the day, clearly it's a large enough building. There's been talk about the 30 foot, you can see on the east side, there's a small setback. Well, the neighbor to the east of that, he has a vacant lot that acts as his side yard to his very substantial home lot that his home is on. He has a 35-foot side yard that is not likely to get built on. It's not a buildable lot. There's a very large setback there. LMM doesn't own it, but it's a large setback. As a charitable institution, Lutheran Metropolitan Ministry and its predecessor organizations have served family and youth in the midst of a residential neighborhood for over 100 years. And that's very similar to other charitable institutions in the neighborhood. And residents, the ones that are signing this letter in support, we've experienced a positive impact from the presence of charitable institutions in our neighborhood, both in offering needed services in our neighborhood and connecting us as volunteers to those charitable institutions. It works both ways. We build community both ways by having those institutions in our neighborhood. Over the past year, a lot of those
All right, Ms. Misak, we'll have to ask you to wrap it up soon. Okay.
Okay. One of the things I want to also say is that the youth leaders have been very much an inspiration to us in this whole process. And they're looking for the same things that we're looking for as neighbors. And we think this is, as a neighborhood, being a residential area, this helps as a location. And then finally, I think there's a recognition, we all know, of the need for this this service, and saying yes to the drop-in center is core really to our values, to the values of those 186 signers as an inclusive neighborhood. And we look forward to seeing this project go forward and making it a reality in our neighborhood. So I thank you very much.
Thank you. I have Brian Ruckus next. Ruckus.
Yes, thank you, Madam Chair. I am, my name is Brian Ruckus. I live at 12 Franklin Boulevard, 400 feet from the proposed site. I am part of a blended family, multiracial, 9 kids, 7 of which are 10 and under. Stop me if you've heard this already. We have poured our time, our love into making our house our forever home. Throughout this process, we have heard LMM and its partners acknowledge that they have done no real research on the neighborhood impact, and have generally been met with the statement that there really shouldn't be much, as the youth themselves have chosen this space, and they just need a place to catch their breath. They have largely ignored the questions that pertain to neighborhood safety and the concerns that we have. They've utilized misinformation, making accusations of racism and classism, and basically vilified those asking any question that didn't kind of conform with their narrative. None of this can be further from the truth. Our concerns are very real and very much rooted in reality. They've presented several surveys, all of which of those surveys were questionnaires. They were done for, by, and with the youth homeless population. And they've presented all the encouraging parts of those surveys to the neighbors, to the 180 that clearly don't live as close to it as we do. And it's all been the rosy picture of what this project could be. That same study, though, what's been omitted is the self-admittance by those participants of the crime that comes along with it. And I know that they've talked about survival crime, and that's all well and good. We can call it survival crime, and it's unfortunate that we term it like that, but crime is still crime, whether it is 70% of them reporting drug use, 30% reporting prostitution or survival sex, and over 23% admitting to theft, assault, or breaking and entering. Now, I know they've touched on those, saying they're just looking for a safe place, a warm place, some food. I understand that, and it's unfortunate that they're in that position. However, bringing that in, bringing those self-reported numbers and bringing that potential for crime to exist into the middle of a zoned residential area does, in fact, cause active harm. If the proposed change in use cannot be any more harmful or objective than the previous non-conforming use, I would think that this would apply, and I would hope that we could look at this and say realistically what the neighbors that are opposed to this has been saying all along, that we definitely encourage you to come into our neighborhood. I keep hearing people talk about our neighborhood, our neighborhood. Yes, our neighborhood is vast and it's big, and there's a wealth of different cultures and just different parts of this that we do as a community, from social services to just being good neighbors. I would implore those same people to hear us when we say we are on your side about the service need. We are not in agreement on location. Now, we've reached out to LMM multiple times to say, work with us to find a suitable location. And I encourage them to continue to do so, but this is not the optimal location. And it should not be something that we just plop in the middle of a residential neighborhood. We should look at things that serve best practices, which this does not. And we should look at things that serve the neighborhood and the people that are in need equally, to build an equal and strong partnership. And this does not. So I thank Madam Chairman, I thank the board for their time and consideration in this. I really encourage you to look at this as a legal issue, but if you can't, look at it from the perspective of the neighbor right next door and say that this shouldn't be something that's granted. And I thank you again.
Thank you. Jeffrey Holmes.
Morning.
Going once.
Good morning,
Good morning.
Madam Chairman, members of the board. Thank you for taking the time on this. My wife and I are the owners of the Stone Gables Inn at 3806 Franklin Boulevard. It's the third house east of the proposed center. I would echo what Brian just said, that we're definitely in support of the drop-in center and LMM's mission, but we do agree that it's not really zoned to be in this location. As a business owner, maybe we bring a little bit different perspective. We certainly feel the impact of the sort of the feel of the street. I mean, we invested a lot of money here to be in.
You're muted.
You're muted, sir.
Can you hear me?
Yes.
Okay. I'm sorry. We invested a lot of time and money here based on the fact that the current zoning would be in place. And a lot of our business relies on sort of the feel and the ambiance of the street. The street is on the National Register of Historic Places. Actually, when the renovations to the inn were done in 2000, they were done under the auspices of the Department of the Interior and the National Park Service, because it is a designated historic site. And a lot of the things that we have to do here, we can't have electric lines touching the house. We can't, all our utilities have to be coming underground. There's a lot of things that we have to do to maintain a property of historic nature. We love old houses. We love the old neighborhood, and that's why we are willing to invest the time and the money in it. And that's what our guests like. A lot of them come because it is a historic building. It is on a historic street. And they come for that ability to walk a historic neighborhood. Now, unfortunately, as was discussed earlier, we are in close proximity to existing number of social services. Within 1,000 feet, we've got the Franklin Plaza, the Herman House, and the Herman House, we'll call it the Annex or whatever, and now Lutheran Methodist Ministries. Our guests already feel the impact of those social services in terms of trash, in terms of, unfortunately, we get public urination going on. We get aggressive panhandling sometimes. And this isn't to say all the experiences are bad with these people. Sometimes they have great interactions with the people down the street, but it's a mixture of people that come, as would come with most places. And so we already feel that impact, and we live with it every day. And so we know that additional services of this type in the neighborhood are going to bring more of that type of impact, because it's the nature of what we live with each and every day. So we do think it will have a negative impact on our business. We run on tight margins. I mean, even a 10% reduction in our revenue would probably bring us, decrease our profits by 50%. I mean, it's very tight margins that we work under. So we think that the increased hours alone that this is going to 8 o'clock at night is, represents a change. We certainly think that the type of services, at least in the perception of our clients, I mean, we would like all of them to be open and welcoming to this, but the truth of the matter is perception. When people decide where they're going to stay, they open up a map, they look at what's around them, and we feel like this would have a negative impact on what their feeling is. And we also know that there can be a negative feeling. Our guests have experienced negative impact of the social community services in the neighborhood already. So I think that sums it up. And
thank you, Mr. Holmes.
Thank you for time.
Yes, and just for the record, you're saying that the negative impact has been from other social service agencies and not from the Lutheran ministry, correct?
Well, we think the proposed use will add to those negative impacts. So
no, I understand, but you're saying the negative, just for the record, that the negative experiences they're getting right now are from other places.
It has been. We've also experienced the fact, just the negative impact from Lutheran Ministries operation in the past, and that to echo Lola, they haven't been a great neighbor in terms of keeping up their property. It's often full of trash. The grass hasn't been mowed. The parking lot looks a mess. So when our guests walk up and down what they want to feel as a historic street, they've often been negatively impacted there.
Okay, thank you.
Thank you.
Okay, next we have Ms. Malone.
I have no further comment. At this time, I did send a letter. Thank you.
All right, thank you. All right, next is Ms. Shank.
Celine, do you want me to speak for the Shank family?
Yes, sorry, I was just trying to get unmuted, but I have kids in the background that are not going to allow me to talk right now, but I'll let them talk.
Okay, thank you. Go ahead.
Robert and Celine Shank, we live across the street, catty corner from the proposed service with our 3 children, 5, 3, and 1. Lived in Ohio City for over 10 years. And, I don't have too much to add beyond what Brian and Dolores and Ron and Jeff and others have stated. I would like to just provide a little bit of context though. I put the presentation together that's included in the materials, and that I understand that the Board of Zoning members have reviewed. I put the presentation together not with the intention of building a case against the service or the location. Our family is supportive of the service. We think it's great. We're supportive of helping people. We're supportive of diversity. We live in Ohio City by choice because of the diversity of the neighborhood, the real integration, the real diversity, and the value that that brings to us as well as our children. But I put the presentation together that's included in here really to answer 2 questions for myself to help form my own personal opinion on whether this is something I should support. And one is this the optimal location from which to operate a county-wide drop-in center? And then what is the potential impact of operating such a service in a residential neighborhood? I had to put this together because, by the way, those are the 2 questions I asked of the leadership of LMM and sort of the consortium of groups from the first meeting onward. And I've consistently asked those questions throughout our engagement with them, which has been a year at this point. And we haven't gotten answers that are sufficient to give the neighbors comfort that, yes, this is the best place to operate this for the young people that are trying to be helped. And we haven't gotten any data around what's the potential impact to the neighborhood. So, I'm not going to go through the presentation exhaustively, but the questions that we started with this is, does it meet a need? There's a need in Cuyahoga County, certainly, right? As we said, this doesn't exist today. But operating from this location doesn't meet established best practice by any means, okay? And I didn't pull some random study on this, and there's a lot of academic research on this topic. I pulled the meta-analysis that sort of aggregated 20 plus papers over the course of, decades of research on this, and assessed this relative to established best practice for operating these things in the best interest of the target population. And the fact of the matter is, this proposed location doesn't meet those criteria. And what you see is this proposed location and the service offerings provided and the accessibility are very, very different than other like centers operated in Ohio. They're very different because they don't meet best practice, okay? So is there a need? Certainly, okay? Is this the best place from which to deliver the service? Doesn't appear so, but I'm not a professional in this space, okay? The question of impact to the neighborhood, is fairly simple. I've been told directly by members of LMM and A Place for Me that we've done no work to assess the impact to the neighborhood. So we tried to look at this from a number of different angles, including at the research, at like services. Look at what Lutheran Metropolitan Ministries and others have said about this. I've talked to elected officials who have far more experience on this than I do. And I've looked at similar services that Lutheran Metropolitan Ministries has operated in Ohio City. And to be honest with you, we don't know what the impact's going to be, okay? But the data suggests there's potential and experienced meaningful negative externalities to the families and the residents that live around this service, okay? Which leads to the final point. Can we trust LMM to operate the service in this location, okay, outside of best practice, in a very different way than other services are operated, where there's all these potential negative externalities to the families? Can we trust them to operate the service in good faith with the neighbor's best interest at heart? Our experience to date as neighbors is no. Our experience to date is that we can't, because they haven't engaged with us in good faith to answer our questions, hear our concerns, address those concerns. And we've reached out repeatedly over the course of over a year in an attempt to engage in meaningful, direct conversation with just the neighbors who are being treated as though we're the opposition here, okay, to see if we can find common ground. And
Okay, Mr. Shank, you gotta.
I will. Yep. So, you know, what I would say is, all the other points aside, we just don't feel like this is we can trust LMM to do what's right by the neighborhood. And I would urge everyone who's ruling on this to look at what happened on West 25th Street when LMM operated a temporary shelter there in Ohio City, and the impact that it had on a once quiet neighborhood, and the way they treated the neighbors when those neighbors raised.
Mr. Shank, that's not before us today, so we can't use that.
Okay, thank you.
Thank you. All right, Patrick McCosker.
Thank you. Thanks for allowing me to speak briefly. I live in Ohio City, about a block and a half from Lutheran Family Services. I'm on West 32nd, a half block south of Franklin, and then from there down Franklin to the site is another block or so. My concern, well, let me just first state that just about everyone in our block club supports the concept and the need of this type of facility, but there are differences of opinion about whether that's the appropriate site. And I fall into the camp where I think there are better sites that would better meet the goals of the planners for this facility. My concern is safety primarily. That's what I want to focus on. And in the block club meetings that I've attended, it was discussed with the leaders that came before us. And Ms. Focia, at one point, when we talked about safety concerns, asked about what the process would be when young people come to this facility. And their approach, which I can understand, is that they want to be an open and welcoming, non-threatening type of environment. And I can understand that. But when it got down to the nuts and bolts of, well, how do you achieve that? Will there be any screening? Will there be metal detectors? And the answer was no. So I don't know how you can, I mean, it's an aspirational thing to say the people coming there understand that it's a weapons-free facility, but, you know, absent verifying that in some way, that's my concern, is that you could have young folks that are armed on the streets, you know, after the closing hours. And the closing hours being defined as 10 hours a day, which means if it closes down at 6 or 7 at night, for half the year, that's at night, you know, that's after dark. So, and I walk a lot up and down Franklin, and I'm just a little bit concerned about public safety. We've had incidences in Ohio City and in our block club on Franklin of robberies and carjackings at gunpoint. So, and I don't want to speculate about what, if this will happen or if it can happen, but it's certainly a definite possibility. And I've not been satisfied with the response I've heard from Ms. Fosha and the people on her team about how they deal with that. And the frustrating thing is if this gets approved, we have no mechanism to control that. That's not, as you pointed out, that's not something that could be defined in the approval of the variance. How do you make that conditional upon you meet this and that and the other thing? It's, and so that leaves us kind of helpless, if it goes through and it's opened and there are problems. And I just want to point that out and see if anyone in the commission has any thoughts on that. So thank you very much.
Thank you. All right, I have Ben Trimble next.
Madam Chair, comments from our organization will be handled by Nate Law. Thank you.
All right, go ahead, Nate.
Good afternoon, Madam Chair, members of the board. I'll be very brief. Just wanted to provide a timeline for community process for this. It's all in the letter, but I'll just reiterate the main points here. On March 7th, 2022, the councilman facilitated a Zoom meeting with the impacted residents and drop-in center project team. On March 15th, 2022, it was presented at an OCI hosted community meeting at Urban Community School. Around January 14th of 2023, this information was publicly posted to Co-Urbanize, which is a community engagement website for the purposes of feedback, and all public information was posted there. And then this also came to the OCI hosted community meeting on January 17th, 2023. And there are 3 times that it was presented to the block club that we are aware of, with the most recent being on January 27th, 2023, with the block club voting in favor 30-21 for this project. And throughout the course of engagement, we've heard support and opposition raised by the neighborhood. Overall, our role in this process has been a facilitator of community engagement, and we have no formal position on the matter. Thank you.
Thank you. Let's see, we got Matt Moss.
Thank you, Madam Chair. I'll keep my comments brief. You've heard lots of testimony on this case. I want to share my perspective as a city staff person, as the neighborhood planner for the area. I've worked now for the Planning Commission for about 4.5 years, a little over 4.5 years. And not only in that time have I come before you all multiple times to discuss land use and land changes and improvements to the neighborhoods like Ohio City, but also other neighborhoods in the city of Cleveland. Some of the work I've done also involves in supporting community organizations like Ohio City Incorporated or others who are seeking to provide or enhance services to the residents in the neighborhood. And that includes all residents, including residents who might be in need of services related to lack of housing or lack of resources, as evidenced by the case today. I want to say that in speaking to whether this use would harm the neighborhood or impose difficulty on the neighborhood, it's been my experience in those years that these types of services are under-resourced in the neighborhood and in the city of Cleveland, as the appellant has stated that there isn't this type of service provided anywhere in the city of Cleveland. And it's difficult to see so much opposition to the provision of those uses that remain chronically under-resourced in our community and in our society today. So from my perspective, while you've heard from the homeowners who live on this street and their opinion and perspective is very relevant to this matter, it's difficult to see the perspectives not shared that I am exposed to through my work, both as a city employee and also, again, with those community organizations. There are people who would benefit from the service, youth in particular, who are a part of this community and are a part of the communities in the city of Cleveland, who need these resources and as you can clearly see, do not have wide access to them. Yeah, there's been some testimony that this isn't accessible via transit or isn't very accessible via transit. I think from our perspective, we consider anything within a 10-minute walk of high-frequency transit to be very accessible. And that would be the bus line on Detroit is a 5-minute walk, which is a 15-minute service, as well as the 51 line on West 25th, which is the second most used bus line in the city of Cleveland, second only to the Health line, is a 10-minute walk from this location. So from my perspective, it is very accessible from transit. I think it's challenging, and I would encourage the board as much as I can to interrogate the concerns of harm and best practice and the demands for information and data from LMM and the appellant, and these negative externalities that you've heard referred to in the testimony, that it's difficult, I think, to make a decision or have an informed opinion when those are inferred rather than clearly specified. So from my perspective, this is providing a use that the neighborhood really needs and would serve residents in the neighborhood. There are homeless youth who are members of the Ohio City neighborhood in the community. There are homeless youth who are Cleveland residents who need these types of services. And I think the fact that other services in Ohio are not located in residential or areas like this that are considered safe, comforting, soothing to users of this service is not necessarily a standard that we should look to replicate here in Cleveland. So thank you.
Thank you. Let's see. I think we got everyone. I will give Mr. Ochner and his team an opportunity to rebut anything that was said in the resident's testimony before I open it up to the board.
Thank you, Madam Chair. I think that some comments have been made about things that people heard from Ms. Fosha that I'd like her to comment on. There's a number of other issues that came up that I think warrant further comment. But I think Maria Fosha, can you talk about what the safety protocols will be for this drop-in center?
Thanks, Ben, Madam Chair. Yes, as I stated earlier, we have the physical safety procedures of the exterior. We will have a safety officer on site at all open hours. This will not be a police officer, a safety officer that's trained to work with young adults in particular, along with a full staff complement of folks that are trained in de-escalation techniques in a trauma-informed manner. So that's, again, no weapons policy. We had not, I don't recall speaking directly to metal detection or not. We are considering that just as an added measure. But we want to make sure that this is a low barrier opportunity for the young people. And we certainly don't want to create a policing type of experience, which we know young people that will be coming here may have had some adverse experiences along those lines.
And there was some comment about garbage and the maintenance of the LMM building, 4100 Franklin.
Just to affirm, LMM has operated the building after the merger since 2017. We've had no citations from the city in regards to keeping up our property.
Okay. Some comments were made about engagement with the neighbors, and I think that I'd ask Ms. D'Orazio to respond to those.
Me too. Thanks, Ben. Yeah, I would just say that we have gone before, as the gentleman from OCI noted, we have presented at the OCI community-wide meetings on 2 separate occasions. We've gone before the leadership as well as the full membership of the Franklin Clinton Block Club on 3 different occasions, and then had some one-on-one conversations with neighbors that were initiated by our team to reach out to the neighbors on either side of the building at 4100 Franklin to have some additional conversation. To the point of impact on the neighborhood, We repeatedly asked the neighbors to further clarify what kind of impact they wanted us to provide responses to. It was difficult to sort of ascertain what exactly they were looking to. They submitted to us a list of more than 40 questions last February, to which we submitted a 15-page response. I believe all of that information's been provided to the board. And we provided in good faith our attempts to document potential impact on traffic at 4100 Franklin, safety and crime in the surrounding neighborhood, interactions with other social service agencies in the neighborhood. In addition to that, last April and May, our team held a series of 8 listening sessions. Invitations went out to 60 of the most immediate households surrounding the property at 4100 with an invitation to come to the building and sit one-on-one with the project partners, to have further conversation and dialogue, to hear their concerns, and to hopefully work together on solutions. I believe that most, if not all, of the neighbors who presented here today participated in one or more of those listening sessions. And we remain committed to ongoing dialogue with the neighbors to be good neighbors at this site, to hear concerns and ensure that those concerns are incorporated into overall service and operations planning.
Thanks, Angela. I also, Mr. Weinstein had some comments.
I just would like to make 2 points related to the comments we heard from several people about their concerns that the usage of the LMM building has been not very intensive, and now this new use is going to be a more intensive use. The first comment is that in my professional experience over 40 years, time and again, I've encountered a situation where a property, for whatever reason, is not being used as intensively as the zoning would permit. And what happens in that instance is, over time, the neighbors take that as the new normal. And subsequently, any effort to do anything, including activities that are absolutely permitted under the existing planning and zoning, meets with opposition from neighbors, because it is an intensification of use from this new normal that they've gotten used to. So this is not unique to this situation. I've seen it numerous times. The other point I want to make in regards to usage is if the proposed use is not allowed at this building, LMM still can use this building for the same types of programs offered to the same population it has at various times in the past. And there is certainly no guarantee at all that the number of individuals served and the automobile traffic generated and the foot traffic generated would not exceed what is anticipated for the proposed use. So from a planning, and in my professional opinion, from a planning and zoning standpoint, this concern about this proposed use intensifying the usage of the building really is a red herring. The building could intensify under the existing zoning with no simply reverting to the uses it has had previously. That's all I have to say. Thank you.
Thank
There are
you.
a few more things that I want to point out, Madam Chairman. I'll be brief. Among other things, I would ask the board to listen to the professionals and not the angry neighbors on what are best practices and what's best for the children, for the young adults. It's that's up to the young adults and to the people who are have put together this program and will be operating it. We did talk about we mentioned 24/7 operation in a context that has been exploited inappropriately, because our point was we want to put this youth drop-in center in a place in this residential neighborhood, as opposed to an industrial area, a manufacturing area, which is and we understand that there will be some concerns about 24/7 operation. Councilman McCormick expressed disagreement with that approach. We figured the neighbors would also not like it, and so we decided that ours would operate up to 10 hours per day. There are no existing limitations on the times during which we can provide social services from that building. And so I think the correct way to look at this is that we've committed to limiting the amount of time that we can use our facility as a charitable institution to provide charitable social services. Mention's been made of the condition of the property and the parking lot. I believe that part of the plans include refinishing the driveway, putting up, repairing and completing the fences, and those are meaningful in that they will aid the neighborhood and the conformity. I'm sorry, the safety and the impact of the neighborhood. Ms. Garcia talks about how this is completely unprecedented. She's wrong, and I will just provide in this sense. There were four youth drop-in centers that have been mentioned in the past. Two were in Columbus, one in Cincinnati, and one in Dayton. The fact of the matter is that a couple of those are very near residential uses. The bigger fact, and the more important fact of the matter is that in all of those zoning districts where youth drop-in centers are located, residential uses are permitted without exception. So we're not really talking about whether or not this is a use that's compatible with residential uses. We've been there for 65 years providing charitable services. And by the way, we were there before everyone else, okay? We've been providing charitable services and social services since before anybody who has spoken owned their property on the block, with perhaps one or two exceptions. Most of the folks who you heard from already moved into a neighborhood that was already beset by the difficulties of which they've complained, without LMM contributing anything at all to those. In addition, the lack of research and the lack of studies, the best study that we have, and you heard it from Ms. Durazio, the best study we have is our experience with the population to be served by this drop-in center. And that experience is we haven't had any crime arise. The use is for people, homeless youth and young adults, to come to the building in the morning and stay as long as they want, up to maybe 10 hours or less. And then they have to go home. And before they go home, LMM makes sure that they have a place to go and a way to get there. So this isn't about loitering. There's not going to be people who are going to be lying on people's patios and at their doorstep or anything like that. We've heard talk about there being no steps to address safety. That's obviously not the case. We've heard mention of a radically different user. I appreciate the sensitivity to reactions to those kinds of comments, but they are what they are. Those comments are what they are. This is a youth drop-in center, most of whom are racial minorities, and most of whom, or many of whom, are LGBTQ. There's an assumption that they're going to commit crime, that they're going to create trash, that they're going to make noise. None of that is supported by any evidence. To the contrary, the only evidence is from A Place for Me and Ms. D'Orazio. Finally, I think Ms. Garcia and Mr. Schenk have mentioned it. Mr. Holmes also commented on the business aspects and pointed out that his margins are very narrow and his place is already located amid much more intensive social charity, social services uses than what LMM is proposing. It's not our desire to adversely impact anyone. But you heard from Ms. Garcia and Mr. Schenk that, in fact, this isn't about the kids. This is about LMM making money. Ms. Fosha, how much are we going to charge people to come and use the center?
That's
Not be
not,
charged to use the center.
yeah, that's not before us today, but thank you for addressing that.
All right, thanks. So there's been a lot more communication with the neighbors than what the neighbors apparently recall. It is true the neighbors have not heard answers that they wanted to hear, but that doesn't mean that they were ignored. And I think that's important to consider. At the end of the day, I would reiterate why this is a permitted use and no variance or special permit is needed. However, nor is it an expansion of a non-conforming use. But to the extent that a variance and or a special permit are required to continue this program with a focus on homeless youth and young adults, we would ask and we would respectfully urge that you have all of the evidence that you need to grant those approvals. I appreciate the chair's indulgence and patience.
All right, thank you. Before I open up to my board, I just want to thank everyone for their testimony and also want to thank everyone for being respectful and trying to be cognizant of time since this has been a long case and testimony. So thank you for that. Board, I open it up to you for any questions or comments, clarifications.
Madam Chair, I have one question. Have we received any official statement from the councilman?
We have. He's in approval.
Okay.
Yeah.
Madam
Good.
Chair, I might also add that the Landmarks Commission has approved this project for the minor exterior renovations that they are doing to the building.
Thank you for that, Maurice. That was going to be my next question.
Madam Chair, I have, I think, I don't know if it's a comment or question, and I think it's more comment. So, in fact, I appreciate the comment that Mr. Offner made at the end. I was wanting more information from LMM with regards to the point about safeguards for preserving the character of the neighborhood or not adversely affecting it. The executive director, when responding to security or safety, really talked about a safety officer for the building, not safeguarding the neighborhood or not adversely affecting the neighborhood. And Mr. Ochner talked about the persons who would receive service when they left have places, homes to go because of the service being provided, perhaps transportation. But the point is to avoid loitering and to not adversely affect the neighborhood. And I'd like to hear a little more about that. Ms. DiRazio, I think, sorry if I'm mispronouncing your name, also talked about ongoing involvement. And so should there be a variance, I really would like to see some comment about or an expectation of continued community involvement and ways in which the services and the persons being served also become part of this community, such as litter patrols and other ways to ensure what else is happening, that there is community. So those are my concerns, and I think that they're valid ones that have been asked that weren't addressed directly by LMM, but has come out during this testimony.
Madam Chair, I'm happy to respond.
Yes, please.
Okay, thank you. Thank you for the questions. Very good questions. And I will begin by saying that LMM does not anticipate having nothing to do with the neighbors. To the contrary, LMM wants this to be successful and will hear out the neighbors with respect to any issues that come up. They're not going to ignore them. They haven't, and they're not going to. As far as, and with respect to the service to the neighborhood, I don't know if LMM has considered that. It sounds to me like a great idea, but I would leave that to Ms. Fosha. Before she speaks to that, in terms of preserving the character of the neighborhood, this is going to have no impact on the character of the neighborhood. The neighborhood is already impacted by a variety of uses, including commercial uses, multifamily, social services, a men's shelter, and this building has always been there, and it's just going to be used for social services like it always has. And to ensure further harmony with the neighborhood, it has LMM is going to install security cameras and lights. They're going to repair and replace the fence. They're going to prevent any kind of trespass to the back of their property by putting in gates. We've had some communication with one of the neighbors about the placement of the gates, with respect to their property line. We are happy to work with the neighbor in connection with that. I would ask Ms. DiRazio to weigh in on to what extent LMM can provide active involvement in the neighboring area.
Sure, I'd be happy to, and it's a wonderful question, and certainly our hope as well. One of the suggestions that came forth through the community engagement process, actually an idea from a neighbor, was that once the center is operational, to establish a steering committee of sorts that would include immediate neighbors as well as youth drop-in center staff and guests to the center to work on continuous quality improvement to make sure that we are keeping a very open channel of communication between the staff and the guests at the center as well as the neighbors. I think that's certainly an idea that we are open to. Safety obviously is important to all of us, of course, for the immediate neighbors as well as for the guests and the staff who will be at the center. So that was just one of many wonderful ideas that came forth through the community engagement process, and one that we would certainly hope to adopt once the center is open at this location. So thank you for asking about that.
Madam Chair, if I may add as well, so part of our conversations with other nonprofit providers have been similar to what Angela is suggesting, that we host quarterly conversations with the neighbors. They've started engaging that process again post-pandemic, and we would see the same as a very constructive way to go forward to engage that. Further, we have heard from many people that they want to be volunteers and engage with this service, and we're able to do that and have built that into our operational plan to have engage the community. That also helps with safety in one way, and very graciously, a number of neighbors have even said that they will be looking out for the young people moving throughout the community, helping to be sure that they know how to get to the bus station and that. So we will certainly have a lot of ambassadors on our side to support that. And finally, in terms of the safety plan, as we've stated in different ways, in different forums, most young people will have a place to go. And the place for me, Navigator team will ensure that they do have a place to go. We have, through a means of transportation, bus passes. LMM operates a shuttle. So we have different ways to actually get young adults where they need to go. And then finally, we've had conversations with Second District Police. We want to continue to keep those communications open, as well as Greater Cleveland RTA Police as well. Keep those communications open. Hopefully, to my comments earlier, we can be a convener, a place to build a bridge with young adults and community policing, and have that as an opportunity at this site. Again, primarily our focus will be on having a security officer that's trained to support us when we're open. But to your question about what happens outside our doors, I wanted to address some of those. I hope that provides some clarity.
Thank you.
If I may, Madam Chair, Ms. Brown, also follow up.
Yes, please, briefly.
Just as a young adult with lived experience and the chair of our youth board, who's been working on the vision and the values of this drop-in center for over 5 years now before LMM was selected, I just want to say that we take very much pride in services and places that actually help us get what we need. And the Reach board will be heavily involved once the drop-in center is open, and keeping upkeep and the place beautiful and a great atmosphere and a place to be in is something that we are going to prioritize as we've been working on this for a long time. And then, speaking to my experience as a youth navigator for the past 4 years, this work is my gospel. And I can say that I have not let one young person that I've worked with over the course of 4 years leave my office or a phone conversation without a plan moving forward. There's been, no interaction or navigation for me that ultimately led a young person sleeping outside in a bus stop or any place like that. And one of the biggest values I appreciate is that we are prioritizing people with lived experience to be hired in this space, so that we're creating more trust with the young adults that we intend to serve, because we've been where they are. And again, we are the experts in what we need. So thank you.
Okay, thank you. Okay, it's 1:04 p.m., everyone. Mr. Vanover from the building inspector would like to say something. So Ms. Brown, can you swear him in? And then we'll be ending testimony.
Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply, I do. State your name and your address, please.
I do. Thomas Vanover, 601 Lakeside Avenue, Cleveland, Ohio. I just have a brief questions, and it's more administrative. It seems that there's been, several conditions that have already been agreed to. I will restate that, to Mr. Ochner's position that a variance is not needed in this hearing. That question has been asked and answered in the previous hearing, but as the body that has to enforce this once granted, if a variance is granted, I'm asking the hours of operation, the hours that they're open, and the safety plan, have those all been formally submitted to the board to be approved as part of the variance so that they could be included in the approval? And then ultimately the certificate of occupancy? And if not, we would ask that those plans be formally submitted so they could become part of the review documents. And therefore we can approve them per the variance, whatever, if a variance is granted. And then we will have the required information for enforcement. It appears to be, it's going to be a complicated process and agreement. And I want to make sure that we have the proper tools and the proper information for enforcement going forward. That's all.
All right,
Thank you.
Ms. DeRazio, I know you spoke before on the hours of operation, but can you just repeat that for the record? The hours and days of the operation.
I'm actually going to ask Maria to jump in here if that's okay. Maria, can you just?
Fine. Yeah.
10 hours a day, 7 days a week. We've discussed either 10 to 8 or 9 to 7, meaning 10 a.m. to 8 p.m., 9 a.m. to 7 p.m. So we're open within that.
Okay, thank you. Okay, any further questions from the board?
Madam Chair, are you comfortable with the two choices of hours of operation?
10 hours.
It's the 10, yeah, the 10 hours. Yeah, I'm comfortable with it. I think, that, I mean, they're so similar that I don't really see the big difference. So I'm just gonna ask LMM to pick ones officially for the record. So you're either gonna do 10 to 8 or 9 to 7.
I would say 9 to 7.
Right.
Okay,
Thank you.
that's what we'll have.
I think that's appropriate. And also, as Mr. Vanover had asked, have you compiled a statement of your security plan for submission to us?
We can just ask for that.
Right.
Yeah, no, we had not been asked prior, but we are, yes, we can do that.
Okay, and will you include in that the metal detector?
Yes, metal detection of some kind, yes.
Okay.
There's a lot of different technologies out there. So.
Right.
Madam Chair, I have just a question. The security plan is not something that I was aware of. Is there a particular provision in the code that requires it? If not, I'm not saying we won't provide it, but I need to record an objection to that just for the purpose of our record. I'm not saying we won't do it, but if there is a specific requirement.
Yeah, no, it's not a requirement, but we're asking for it so that it can be used for building a housing when they are inspecting or whatever. So those things need to be on the record.
Madam Chairman, just I apologize if I wasn't clear. If the variance is going to be considered because of the promise of a security plan, which has been made at least 24 times in this hearing, that security is not going to be an issue because they're promising that there will be a security plan. If that testimony is going to be considered in granting the variance, then we would ask that that also be submitted so that it could be enforced. once the variance is granted requiring it.
Yeah, we got you.
Does that answer your question, Mr. Ochner?
Yes, and while I'm tempted to
Muted.
withdraw my objection,
Okay.
I'm just going to leave it as is. I'm not saying that's unreasonable. We're going to provide a security plan, and Mr. Vanover makes a good point, and so that answers my question. Thank you.
I think it offers vehicles so that that evaluation of anything is not subjective if it becomes very objective. Or subjective, it becomes objective. So that everyone's on the same page.
I would agree.
Okay.
Thank you.
Madam Chair, if there's no comments or other questions from my colleagues.
Go ahead with a motion.
Okay. Extensive testimony today, as as the chairwoman has stated. We thank everyone for their time, their comments, their interest in this case, and everyone's engagement in the process. With that being said, we have on record a letter of support from Councilman McCormick. We have heard from the CDC as to the timetable and number of public meetings and opportunity for public input that has been given. We have heard from city planning in terms of the accessibility to public transit, and we have heard from the appellant as to the assurance that they will make sure that all those that use their services will be provided transportation and will have housing found for them off this site, so that no one should be left on site overnight or loitering on the premises. We have discussed the hours of operation, which will be limited to 9 a.m. to 7 p.m. That will be 7 days a week. And the appellant's agents have agreed to submit a security plan once that is completely formulated and in place with all stakeholders, all parties involved in making that come to fruition. So with all that being said, Madam Chair, I move that we go ahead and approve variance for calendar number 22-213.
Thank you. Can I have a second, please?
Board Member Holbert, a second.
Ms. Holzer with the second. Go ahead, call the roll.
Ms. Brown?
Yes.
Ms. Holzer?
Yes.
Ms. Faith?
Yes.
Ms. Britz?
Yes.
Calendar number 22-213 is granted conditionally. Madam Chair, will we hold ratification until we receive the security plan?
Yes.
We'll hold ratification until we receive that, and once we receive that, we will ratify the case the following Monday and send the appellant a letter.
All right. Thank you, everyone.
Thank you.
Thank you.
All right. Old business 1 through 7 and 12 and 13 without objection.
Without objection.
Without objection.
All right. And what's going on with this, with the miscellaneous list?
So Madam Chair, this person was granted a variance to have a patio behind his building for his use. I believe he was proposing a bar at the time. He came to us with a slightly different plan and just wanted to bring it to you so you guys lay eyes on it and see if there's anything that stood out. To me, it looked very similar. I think Maurice Rulins also believed that it looked very similar too. The only thing that we could find that might have been different is the highlighted fence area. But it does look like a fence was always proposed there, but they're pushing it closer to the sidewalk. If you think this is a good enough reason to bring it back to the board for another hearing, we can do that. If you think this is okay, we'll go ahead and send it back over to Building and Housing.
Yeah, I don't think this has been altered to the point to where we need to rehear it. Board, what do you think?
I'm in agreement. I looked at the plans. I didn't see any substantial changes either. So
I mean, what we
They
really
need
objected,
to no additional curb cut on St. Clair.
I'm sorry, I didn't hear you, Terry. What'd you say?
I said what we really objected to was any kind of curb cut on St. Clair that allowed them to drive the cars on and park up there. So as long as that isn't added, I don't think I have an objection.
Yeah, this
It
plan
doesn't
shows,
appear like they're doing that, so.
Yeah. All right.
Although
Well, I think
the one entrance by the dumpster, it looks like it is large enough to probably get a garbage truck in there to actually pick up that dumpster.
Yeah.
So I don't know if that means they're going to have a garbage truck jumping that curb there on St. Clair. I guess that's the only thing that I can see that could be potentially be a problem.
Well, you guys could do an administrative review on that. That wouldn't require us in a new hearing.
Yeah.
Right.
And yeah, I don't think I just don't think the plan's been altered enough for us to hear it again. So
I don't believe he'd be
I just
putting
wanted
in any new, he was never proposing any new curb cuts. I believe they were existing.
that was existing. Yeah.
Right.
There were no new ones.
Okay.
They were just
Right.
big. They
Yeah.
were just big curb cuts, but there were no new ones.
Okay.
All
Okay,
right.
thank you, board.
You're welcome.
All right. Bye, everybody.
Thanks,
Bye.
Hi,
everybody.
everybody.
Fun.
All right, thank you.
Enjoy the rest of your days, everyone.
Yeah, thanks.
Not much left.
Yeah.
Bye.
A power nap and then move on. Bye.
Bye.